to broadcast. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 18-3041 et al. United States of America versus Ahmed Abukhatallah, also known as 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 Sheikh Appellant. Ms. Shikatov for Ahmed Abukhatallah, Mr. Lenners for the United States of America.
Counsel, thank you. I know we have a cross appeal and a cross appeal here. And so I think the best way to go forward at this point is that we will have sorry, am I saying it right? Ms. Shekatov? Did I say that right? Ms. Shekatov. Why don't you start with your argument on your primary issues, only not on the sentencing issue that the government has raised. And then we will switch to the government and they can both respond to your arguments and address affirmatively at argument their cross appeal. And we'll make sure everyone has the time they need. I know it's sort of woodenly just set at 30 minutes, but don't worry about that. And then when Ms. Shekatov, when you get up for a rebuttal, it'll be both responsive and rebuttal, and we'll give you the time that's warranted for that. And then Mr. Lenners can do the final rebuttal just on his cross appeal. Does that make sense to everybody?
That sounds great.
Yeah, fantastic, thank you. All right, and you can begin then, Ms. Shekatov.
Good morning, Your Honors, and may it please the court. There are 4 issues today in Mr. Katallah's cross appeal. I'd like to start by addressing the erroneous admission of one of the key pieces of evidence against Mr. Abukhatallah, a spreadsheet that the government said cataloged his calls before and during the attacks on the mission and the annex.
Excuse me, sorry, I don't know if anyone else is, I'm having a little trouble hearing you. I can hear you, but it's a little distant sounding.
Yeah, same with me.
So sorry, we did a sound check and it was working well, but I will bring
That's how it always works for me too. It's fine at the sound check and then it doesn't work in reality.
Should I start from the beginning?
I think we all heard it, but
We heard it.
just, yeah, as loud as you can project, please.
Okay. The government specifically chose not to authenticate the spreadsheet at trial because it believed it had discharged its authentication duty by authenticating a spreadsheet at a pretrial hearing outside the presence of the jury. That was a legal error and it was enormously prejudicial. The government can't satisfy its burden to show that the error was harmless.
No, at trial, the counsel for your client specifically said, we're not asking the government to put in the certificate of authenticity. It was on page 2590 of the trial transcript. And then it wasn't raised in your brief here until the reply brief. So how do we, as to the certificate of authenticity argument, is that even before us?
Yes, just to be clear, we're not saying that the certificate of authenticity needed to be introduced to the jury. The government might have tried to introduce that as one way to authenticate the spreadsheet. The claim that we raised below and that we've raised here consistently is that the spreadsheet needed to be authenticated. Now, if the question is, could it have been authenticated with that specific certification? I think there's a question about that. Our position at trial was that it violated Mr. Katallah's confrontation clause rights. And so that's why we didn't think that would suffice. We thought it would suffice as an authentication matter, but not under the confrontation clause. And obviously the government can't circumvent Mr. Katallah's confrontation clause rights by simply not authenticating at all. But our claim has always been that they needed to introduce some evidence to authenticate the spreadsheet, and they did nothing.
So on your view, this whole set of issues about authentication boils down to a question of the sufficiency of evidence before the jury on that point.
That's basically correct. And Rule 104B and the commentary to that rule and all the case law interpreting that rule makes clear that authentication is an aspect or is a matter of conditional relevance. That's a question that goes to the jury. And so it's not enough to satisfy an authentication burden by simply presenting evidence to the judge. To be clear,
what do you do? What do you do with the statute? So you have a good argument that that's how authentication normally works under the federal rules of evidence, but there's a statute that very specifically addresses authentication in this context. And it seems to say that the authentication decision is made once, it's made by the court, and it's made before the trial.
Respectfully, I don't read the statute to say that. I understand the statute to say that this quantity or this particular piece of evidence, that is a certification, does satisfy both the hearsay rule and also the authentication requirement. But it does not say that the generally understood rule that authentication is something that needs to be done before the jury is something that remains something done before the jury. And just to back up,
it says certification shall authenticate. And then it says, if you want to oppose admission of this kind of record for lack of authentication, the motion shall be made and determined by the court before trial. And then it says the failure to file such a motion shall constitute a waiver of objection to such record.
Right, and that's actually not that inconsistent with the basic procedure under the federal rules for authentication with certificates either. There's a pretrial opportunity to say, hey, this certification is insufficient, or this certification is problematic and we need discovery about this, that kind of thing. But that really doesn't speak to whether the certification or other evidence of authentication subsequently needs to be introduced to the jury. The question is always one for the jury. That is relevancy and conditional relevancy are basic tenets of what the jury always needs to decide.
Well, I'm not sure that's right, though, because Rule 901 on background rules, Rule 901 says that part of authentication is producing sufficient evidence to support the finding, right? To authenticate, the proponent must do that. That is part of authentication under the background rules. The statute says the pretrial determination by the judge shall authenticate.
Respectfully, I don't think that's what it says. It says the certification shall authenticate. In other words, the certification is a sufficient amount of evidence that will authenticate. That's analogous to what 902 says about other self-authenticating pieces of evidence. But in the end, that still needs to be introduced to the jury, because otherwise the jury has no basis to determine that these, quote unquote, phone records are actually phone records. And maybe it would help just to back up a little bit. Again, when I say this is a matter of conditional relevancy, just to flesh that out a bit, the jury is given a piece of evidence and told, this is XYZ, this is a certification this is phone records of Mr. Catallah's calls. They need to have, in order to accept that representation, they need to have some basis to conclude that it actually is that. Otherwise, it's on its face irrelevant. That's why this evidence needs to go to the jury in the first place. And I believe that, I don't think it's disputed that the statute is intended to sort of supplement the rules, because the rules allow a self-authentication procedure for civil records or records in civil trials and things like that.
But Ms. Shekatov, even if you're correct about that, it seems that the court here did not rely only on the pretrial authentication, right? I mean, the relevancy and authenticity of the phone records was contested throughout the trial, and it was highlighted in the closing arguments. So given that was all before the jury, what is your best argument about sufficiency of the evidence, putting aside the pretrial authentication?
Okay. So can I say two things? The first, in terms of the standard of review, if you're assessing it that way, I do want to be clear that even though abuse of discretion review would generally apply if you're assessing whether the authentication burden is met. Here, because the judge made a legal error, it did not even assess whether the authentication burden was met. So you would not be reviewing for abuse of discretion. You would be deciding de novo whether that authentication burden was met. And the government doesn't dispute that. So then to answer your substantive question, there really was no evidence before the jury that's legally sufficient. I mean, the government says, well, look at the spreadsheet itself. On its face, it's phone records. Well, I mean, that would really eliminate the entire duty of authentication. It's a black and white table, dozens of pages. It doesn't even have like a logo on it. Not that a logo would necessarily suffice, but there's really nothing that would tie it either to Liviana, that's the company that supposedly produced these records and maintained them. And there's certainly nothing to suggest that these are actually accurately maintained in records of real phone calls that happened.
So Ms. Shukadov, can I just, it seems to me there's two types of what you would call authentication here. You know, first is a judge has to decide that something is, as a matter of law, sufficiently what it is, that it could even go before the jury. And that's what the pretrial hearing did here. And you don't challenge that aspect of the district court's decision. So it's a matter of law. This was sufficient to go before the jury. And then you had the opportunity to argue to the court, to the jury. And I think your prior counsel, Mr. Catalase counsel did, and quite, thoroughly raised all of the arguments that you're raising here about, you can't rely on, who knows what this thing is. It could have been typed up on someone's computer. It doesn't look like anything, and a security guard of all people to vouch for it. So all of those arguments were made, and it seems to me the authentication argument before the jury you're making is sort of folded in with should you credit this? Is this evidence that's something you should credit, that you should deem credible? And all of those arguments were made. And, at this stage, we take the light in the most favorable, the evidence light most favorable to the verdict, at which point I don't know if we do that and everything was vetted thoroughly. All of these arguments, it didn't impinge anything on your ability to make any arguments to the jury. If lack of authenticity is in the record, that's a problem for the proponent, not really for the defendant, because you agree that the legal question of whether this was sufficiently authentic for a jury to even see it was met. And so I'm having trouble understanding what more could have happened. If they didn't think it was authentic, that hurt the government, not you. And if they were on the offense, you argued everything that nothing would change in your arguments.
Right. Two responses, Your Honor. First, I think, the fact that there was sufficient evidence produced before a judge does not really say anything about whether there was sufficient evidence that the jury should have looked at it. I agree that
just to be clear, should have looked at it, because if you think about this, kind of analogous to the statute's kind of analogous to the Daubert process. First, you have to have, or Dobert, I don't know how to pronounce it, but first the judge makes a cut at whether this is even sufficient as a matter of law that it can go before a jury. And then it goes before the jury and everybody argues all they want about whether you should credit it or not, and whether this person's reliable or not. And I don't know that the authenticity arguments that you're talking about are any different than you should credit or not this, this is credible and something you should rely on as a jury.
Right, but the function of Rule 104B is as a gatekeeping function. And the idea is to say,
you haven't challenged the district court's, I haven't read you to challenge the district court's decision that this gets through the gate.
That is what I'm challenging. That is what I'm challenging, in that the district court did not actually assess the evidence that went before the jury. The district court assessed the evidence that went before itself and determined that met the threshold. But what the district court should be determined.
The statute says that is the gatekeeping function. When it meets that statutory threshold, it is eligible to go before a jury. And then it's you all have at it on whether it's
analogize. This is analogous to insufficient evidence, period, for conviction. It would not be enough for the judge to say in a pretrial hearing, oh, hey, government, this does seem like enough to convict. You do get to proceed with this trial. And then to have the government not introduce that evidence to the jury and then just say to the jury, well, he's definitely guilty. Here's one piece of evidence you should convict. If the jury then convicts, you can't look at that and say, well, it wasn't prejudicial because the defense had the opportunity to say, hey, that wasn't enough evidence. The bottom line is there's a legal threshold about what sufficient evidence needs to be produced to the jury. If that threshold is not met, there is prejudice, there's a problem. It's not enough to just be able to argue about it. Here, the purpose of Rule 104B is to ensure that evidence is not put before the jury that could be highly prejudicial when there really is no legal basis to tell the jury that this is in fact what it is. There is a risk that the jury will nonetheless say, yeah, that, this looks really, this is black and white. This has specific seconds and cell towers and tons of phone numbers. This looks really reliable and we are going to credit this. You need to have, because of that worry, that's why the judge serves its gatekeeping function. And it's not serving a gatekeeping function if it's looking at evidence outside the presence of the jury that the jury never sees. That's not the gatekeeping function, is to make sure that the evidence before the jury gives the jury a sufficient basis to draw the inference that this piece of evidence is in fact what the government claims.
The jury can't, I mean, the judge can't perform that second level of gatekeeping that you want until after the fact, right?
You're right that, so you can do it
So it's really,
two ways.
so really what you're complaining about is the not the conditional admission of the evidence, but the fact that the district court didn't later grant a motion to strike.
No, that's not correct. When under Rule 104, or actually I can't remember the exact rule, but
the judge made the authentication, the front end gatekeeping through the certification, and you don't contest that.
Mm-hmm.
And then he admits the evidence subject to the authentication predicates being established through evidence. He says you have to re-authenticate before the jury.
Well, that's the piece that he doesn't do. He doesn't say, okay, so at a pretrial hearing, it's correct that the judge can look at the evidence and say, yes, this would meet the threshold. If you introduce this evidence, yes, I will allow this to be admitted before the jury. Another way to do it is to say at trial, when the government makes its proffer, yes, I am admitting this subject to connection up later. Those are the two ways. But in either case, the government actually does have to produce that proof later. And that's the problem here. The government never did that. And the judge did not say that it had to. Just to be clear, when the judge admitted these records, the judge said, I'm admitting these because of the pretrial, presentation you made. There was no, subject to connection up. There was no further burden on the government to authenticate, and therefore, and in fact, the government was quite clear it was not trying to authenticate these records. So that is the problem that we're complaining about.
And it seems to me that when you talk about sufficiency of the evidence, here, it's not so much just a freestanding sufficiency evidence, because you have to tie it to counts for which he was convicted. So it seems to me at the end of the day, what you need to show is even, if we assume there was, even if we assume there wasn't sufficient evidence, do we have a showing of prejudice as to the 4 counts on which he was convicted, not the other ones, but the 4 counts on which he was convicted? And it seemed to me that there was other evidence, testimonial evidence, connecting him for the purposes of the conspiracy counts and for purposes of 1363, that he was, his interactions with people, testimony about his interactions with people, video evidence of him there at the scene. Was it prejudicial? Was it prejudicial? Even
Yes. I'm sure you're surprised to hear my answer. Yes. And the government has the burden to show harmlessness here. It was prejudicial. The jury, yes, the jury acquitted on 14 counts and convicted on 4. But this was extremely prejudicial or extremely inculpatory evidence that went to all of the counts. This was not independent, and it did not only go to the acquitted counts. And it was highly relevant to the convicted counts because it showed that Mr. Abukhatallah had connections to the people that he supposedly conspired with. You alluded to video. Yes, there was video. There was some dispute about whether Mr. Abukhatallah was really in those videos, but at most those videos showed Mr. Abukhatallah was present at the mission. And that's what distinguishes the second part of the attack from the other parts of the attack. There was video at least showing that he was there. So yes, there was more evidence that Mr. Abukhatallah was involved in the second parts of the attack. But still, Mr. Abukhatallah did not injure any building himself. There's no video of him breaking down a door or setting a fire. And so the way that the government made its case was to say, well, look, he's connected to all these people who did do those things. And a key way that the government did that, as you can see from our brief, is just over and over again point to these phone records. And the government in its brief says, well, most of those phone records were really about other counts. I think that that's true most, but there was an extraordinary amount still about these calls, about this time. There's, I think on A669 of our appendix, there's a lengthy I think, 2 paragraphs about how there's 16 calls between Mr. Katallah between 10:20 and the second wave of the attack, where he's talking to all of his compatriots. There's an 18-minute call with Al Imam, which was right before the attacks. I mean, there's just no way that the government can say we definitely would have prevailed, even absent these phone records or quote unquote phone records. And I think you can see that to some extent from the acquittals. The fact that the jury did not find this case to be overwhelming is really something, and says how much these phone records must have mattered for the convicted counts, because the only other thing that you have is basically the video. If that standing alone, that the video is obviously not enough. So the jury must have tied this together with these other records.
If my colleagues don't have more questions on this issue, did you want to turn to another issue?
Yes, thank you. Following the Supreme Court's decision in Davis, it's now clear that Mr. Katallah's conviction for carrying a gun in connection with a crime of violence can't stand. There's insufficient evidence that he committed a crime of violence. The only crime of violence that the government defends is his conviction under 1363. But the jury was instructed that Mr. Katallah could be convicted for either conspiring to injure a building or injuring a building. And everyone now agrees that conspiring to injure a building is not enough. Mr. Katallah is entitled to acquittal.
Mr. Katallah did not challenge his 924C conviction on the same argument that you are raising here with respect to conspiracy. Isn't that correct? So don't we review that under plain error?
Mr. Katallah made a generally stated motion for judgment of acquittal at the close of the government's case, and then at the end of trial. And under the circuit's precedent, making a motion, a general motion like that, suffices to preserve all challenges to the sufficiency of the evidence. And the government doesn't disagree. It doesn't dispute that this is reviewed de novo. The fact that Mr. Katallah also made a more specific.
Sorry, go ahead. I'm sorry.
The fact that that Mr. Katallah also made a separate motion for judgment of acquittal and raised specific grounds doesn't change the fact that he separately made a general motion that does suffice to preserve all claims.
So then does the general motion suffice? I mean, so then is there no forfeiture so long as a defendant raises a general argument about, makes a general motion for acquittal? I mean, are there no issues that can be forfeited then under that?
This is only for sufficiency of the evidence, but that is my understanding of circuit precedent. This court has said again and again and again, generally stated motion for judgment of acquittal preserves all challenges to the sufficiency of the evidence. And again, even if the court wanted to make an exception in certain cases, this isn't the case to do that, because the government doesn't dispute that he preserved this claim.
Is this really a sufficiency argument, though? I mean, suppose I think the following, that the substantive offense is a crime of violence. The conspiracy offense is not a crime of violence. The statute is divisible between the substantive and the conspiracy offense. There's more than sufficient evidence to support a conviction on the substantive offense. And the problem here is that the instructional error makes it arguably hard or impossible to figure out whether he was validly convicted of the substantive offense or invalidly convicted of the conspiracy offense. If that's what I think about all those issues, this is not a sufficiency problem. This is an instructional error problem.
Just to clarify, when you're talking about instructional error, are you talking about the instructional error that we point to, saying counts 1 to 17 are crimes of, 3 to 17 are crimes of violence? Or are you talking about the quote unquote instructional error about conspiring to injure a building versus injuring a building?
Yeah, I think I'm talking about the second one, because my framing was designed to eliminate the first one by saying I think it's divisible into one crime that is the substantive offense, which is a crime of violence, and the conspiracy offense, which is not.
Right. I would say there is no instructional error with that second piece. It was not error to, or Mr. Katala is not complaining of any error in that second instruction. That instruction coheres with the law, the statute as written. The reason that instruction creates difficulty for the crime of violence conviction. So, sorry, just to step back also, the instruction we're talking about is the instruction on count 16. And this count,
yeah,
this
okay,
challenge is to count.
So maybe you're right that both instructions that you mention are on the table.
Well, we are raising a separate challenge to the instructional error that counts. I think it's counts 1 through 17 are crimes of violence.
Right.
But on the sufficiency piece, what the government is saying is that we're really complaining about the instructional error that you were just pointing to in 1363 on count 16, and about conspiring versus actually doing the injuring. And like I was saying, I don't think that is an instructional error. We're not complaining about that. That is just under the Supreme Court's decision in Mathis. That is what creates the legal lack of certainty. That means that we can't ascertain what Mr. Katala was in fact convicted of doing. And that's just what the categorical approach is. I don't think that changes this from a sufficiency challenge to an instructional challenge. That's just a product of the categorical approach.
So let me just amend my framing a little bit to account for one good point that you made. So let's say then there is an instructional error in categorically defining the offense described in count 16 as a crime of violence in a case where the government charged both conspiracy and the substantive offense. But that's still an instructional error as opposed to an argument that there wasn't legally sufficient evidence to support the conviction on count 16.
Well, to clarify, we are also raising an instructional error claim, which you're basically well summarizing. The reason I don't think that means that this is not a legal insufficiency challenge. I mean, the point is that Mr. Katala was convicted of, we cannot, under the modified categorical approach, we cannot determine, and this is assuming the modified categorical approach even applies, we cannot determine whether it was conspiracy or actually doing the injuring. And so there is not sufficient evidence to say that he was convicted of a crime of violence.
I guess I don't see that as a sufficiency argument.
Or maybe I could put it a different way. The crime, I'm sorry.
No, go ahead.
The crime of which he was convicted was conspiring or injuring a building. That is a crime of conviction. That is not a crime of violence. Therefore, there is insufficient evidence of carrying a gun in connection with a crime of violence under count 18. Under the modified categorical approach, the only thing we can say about count 16 or about his conviction is that he injured or conspired to injure a building. And since that is not a crime of violence. Unless we can unpack through the modified categorical inquiry, unless we can unpack things and say the jury must have convicted on the substantive offense. That's correct, with one caveat. I agree that if you believe that the modified categorical approach applies and that you believe there is sufficient legal certainty to determine that Mr. Katala was convicted of injuring a building rather than conspiring, then that's a problem for us. But the Supreme Court has been very clear that the court's role is not to determine whether it's most likely or very likely or even actually almost certain that Mr. Katala was convicted of actually injuring a building. The question is, as a legal matter, looking at the indictment, looking at the jury instructions, what can you be legally certain that he was necessarily convicted of? And there is no such legal certainty here. Yeah. I'm sorry. Yeah, I mean, I understand that's your argument. I wasn't meaning to pretermit it. I guess this was all the jumping off point for all of this was just your response to Judge Rao that you get a de novo shot at all of these issues just because you filed an acquittal motion invoking sufficiency. That's what I'm
skeptical of. I understand your argument about this is too hard to unpack, and you can elaborate on that as much as you like.
Well, the other thing I'll say in response to your concern and Judge Rao's concern is just that the government, again, doesn't contest this. So, they don't contest that this is a proper legal sufficiency argument, and they don't contest that the standard of review is de novo here. And so
even as to the jury instructions issue, the law changed, right? The law was one thing at the time the jury in this circuit was one thing at the time the jury instructions were submitted.
That's right.
We agreed to them, and I think we've pretty much recognized repeatedly that it's not considered a forfeiture in that context, or invited error, whatever one wants to label it, when the law at the level of the Supreme Court has changed in the interim.
Right. The government's argument is that this is invited error on the instructional piece, because we proposed jury instructions together with the government about this, about how counts 1 through 17 are crimes of violence. But like you said, Judge, the law radically changed. It went from binding circuit precedent saying the residual clause is valid to very direct Supreme Court precedent saying it's not valid. And
saying that conspiracy was a crime of violence. Or indicating anyhow.
I am not sure that the Supreme Court has resolved the conspiracy piece, but the government does not contest, and I think every circuit agrees now. I'm not sure if this circuit, I don't think this circuit has taken a position yet.
That's fair. That's fair. But the government itself agrees.
The government itself agrees. The Solicitor General has stated. I think it's, and I don't see any legal argument about how a conspiracy could be sufficient at this stage. That the Third Circuit and the 10th Circuit have both recognized that invited error doctrine is not applicable in those circumstances, because really, what is the defendant supposed to do? I mean, the defendant couldn't say, I won't agree to this instruction because it's what binding circuit law requires.
Invited error might not apply, but I'm not sure we've said plain error doesn't apply.
I think you are right about that, and we're not saying that we don't have to meet the plain error standard.
Okay. If you just say maybe briefly why you think there would be prejudice here if we thought the plain error standard was the applicable one.
Sorry, actually, let me I'm so sorry. I just want to make sure I didn't say something to you. Okay, no, I didn't. We agree that. I'm sorry, you asked about prejudice?
Right.
Well, I think it is clear now that conspiracy is not a crime of violence, and so it certainly would have affected the outcome of the proceedings.
Well, isn't it Mr. Catallah's burden to show that there's a reasonable probability that the outcome would be different?
As a matter of law, yes, that's correct. And as a matter of law, because count 16, again, assuming the modified categorical approach does apply, and there's still a lack of legal certainty to say whether he was convicted of conspiring or injuring a building. And so, for that reason, we can't say that was a crime of violence. So correctly instructed, the jury would not have, or there's certainly a reasonable probability that the jury would not have convicted on this count. And then just to back up for a second.
Correctly instructed, it's quite possible that the jury would have convicted on the substantive crime of 1363.
Again, we're not challenging the instruction on 1363, whether it was conspiring or actually injuring a building. That's not, so that's, I don't see that as part of the inquiry. It's not that if they were instructed only that they had to find that he actually injured a building, would they have convicted? I think the question is, if they were correctly instructed that count 16 isn't inherently a crime of violence, and if we're applying the correct law, which says that, count 16 is not a crime of violence because he was in fact convicted of either conspiring or injuring a building, then that shows a reasonable probability that the outcome would have been different. And then just to also clarify, it's not our job to show that there's no reasonable probability that some other outcome wouldn't have happened. It's just that, or that the same outcome wouldn't have happened. It's our burden to show that a different outcome could have happened. I think we go well beyond that here because, if count 16 is in fact not a crime of violence as a matter of law, which is what we're saying, given what his count 16 conviction actually was, then sort of by definition, the jury couldn't have convicted on count 18 because the government isn't even defending count 18 on the basis of count 1 or count 2 being a crime of violence.
What is sorry, I just want to make sure I'm keeping things straight here. The requirement of, in this context of legal certainty as to what the jury did, how does that intersect with our plain error? Does that heighten or does that reduce your burden to show prejudice when we're doing the plain error doctrine? Or do we just have to keep those things separate? I'm trying to figure out how they might interact here.
So the legal certainty question is more, I think, about count 16 and what does the conviction of count 16 mean? And so I don't know that intersects directly with the plain error standard, which I think, well, let me think about your question more.
It just seems odd if we have to find legal certainty, but then if we say we're in a plain error land, then we can do more generous reading of the record than we could under the legal certainty standard. Yet what we have to do here is find whether he was convicted of an actual crime of violence. Are we legally certain that he was committed by an actual crime of violence by the jury? And does that requirement of legal certainty, is there any case that says that requirement of legal certainty, that I think is about the highest standard you could have, diminishes in a plain error context, because we still have to find that crime of violence?
I haven't seen any such case, but I think it's possible that those things do intersect to some.
Because it's just, I mean, the jury instructions at issue here were also submitted by the government. So you, at a minimum, you guys are both in the same boat on any problems on the jury instructions. So I think that's a lot. I mean, the jury instruction defined it as a single element, whether you substantively destroy or injure or attempt or aid or abet or conspiracy. It was expressly defined by the jury instructions as the first element of 1363, and that was as much of the government's instruction as yours.
Right.
And so how we allocate any concerns now about what that instruction, if we think that they should have been defined as two separate crimes, two separate elements at least to be found, alternative elements to have been found. And I'm just having trouble mapping that onto the plain error standard.
Right. Well, I completely agree that the government
here.
I'm sorry.
It just seems to me, I mean, I assume that's why you don't challenge that instruction, right? Because you think it's not a divisible statute.
Right. We think
that has created a lot of confusion about what the jury did as to the 1363 conviction.
Even if it were divisible, we're not saying it's an error. I mean, I completely agree that the government had equal responsibility for proposing it. And so it's a little strange for them to be saying we can't complain about it. But I guess setting that aside, it's not that it was incorrect or we're saying that there's a legal problem with having instructed the jury that way. It's just that as a natural consequence or a necessary legal consequence of that, we cannot say that the jury the conviction is for conspiring and injuring rather than one or the other, to the extent the statute is divisible. And so there is no legal certainty. And so applying the plain error standard on top of that, the question is basically, is it clear that, that this is not a crime of violence? And I would say it's extremely clear. I mean, conspiracy does not have as an element. And again, the government doesn't dispute this. So I don't think the government is disputing this aspect of plain error. That conspiracy does not have a use of force element or attempted or threatened use of force. And so it's simply not a crime of violence. Would it make sense for me to move on to the next issue?
Yes, unless my colleagues have other questions. Okay. And which issues you want to talk about are entirely within your discretion. If we want to talk about something you don't want to, then I don't want you to feel like you have to march through everything for our sake.
Okay, thank you. I would like to do 4 in total. This one is the issue 4 in our brief. Mr. Catallah's 1363 conviction, and that's count 16, is invalid because there was no evidence that the offense was committed against an American. This is a property crime, so it's not the kind of crime that's committed against a person at all. And regardless, the jury was not told about this element. The court should order acquittal or vacatur, and it should do the same for all of the remaining counts.
Do you argue that if the jury found that someone's well-being was put into jeopardy as a result of this attack, was there anything in the record that showed that there was anybody other than American whose life was imperiled with this attack?
Yes. So, I mean, there are many Libyans on the mission property. So there's the February 17 guards. There are, of course, other attackers. There are.
Is there any evidence in the record? Did you, as a defense, introduce any evidence into the record that any of their lives were at any time imperiled?
I think that the idea is the same for everyone else who was not. Well, sorry. Let me just back up and say. So the jury verdicts make clear that Mr. Abukhatallah was not convicted for putting the lives of officers of the 4 Americans who perished in this attack in danger, because he was acquitted of those murders. So we're talking about.
I think the jury said it didn't result in death. That's not the same thing as saying lives in peril, is it?
Well, basically the question I think would be, did he have anything to do with the fires that caused their deaths? They were put in danger in the same way that they were ultimately killed. So I don't think that he was responsible for them. So, but just to back up, the attackers stormed the compound, fires were set, guns were fired, and so I think lives were put in danger. If you hold Mr. Abukhatallah responsible for,
But we're talking about. I thought you were talking about in Section 7(9), the sort of jurisdictional element, and that doesn't even require. It just says there has to be an offense committed against a national of the United States, right?
Right. So 1363.
That wouldn't have to be actually the death or imperiling death, right?
Yes, I'm sorry. I'm just trying to explain what I understand the verdicts to mean. But yes, 1363. He was convicted of injuring or conspiring to injure a dwelling and putting lives in danger or injuring a dwelling. And we are fighting to some extent on what there's evidence of. And you're asking, well, were other people's lives put in danger? And I would say there's evidence, to the extent that he put anyone's life in danger, it would have similarly been either other attackers or.
Yes, I apologize. I didn't phrase it properly. Is there any evidence in the record that there was an offense was committed against anyone who was not an American?
I would say that I don't think there is evidence in the record that Mr. Abukhatallah committed an offense against any person at all, because these are property crimes that he was convicted of. These are crimes that are committed against property, and it doesn't really.
They're property crime because the jury also found the enhanced responsibility for either attacking a dwelling or putting a person's life in jeopardy, or putting a person in jeopardy.
And even under. I guess 2 things, Your Honor. Number one, to the extent it's about a dwelling, I don't think that is against a person. I mean, if the fact that someone sleeps in a building doesn't make it again a property crime against that building, against a person, I just don't think that I don't think we would say Mr. Abukhatallah injured a building against a U.S. national. It doesn't really make sense linguistically.
Somebody blows my house when I'm not there. Is that not an offense against me?
I don't think so. I mean, I think. But if you disagree, we still.
I would feel very offended.
I just don't think that that's how Congress was looking at this statute. I think it raises a host of questions about what it means to be against a person. You would have to really parse the record to see and make all sorts of determinations. It would be quite, I think, difficult to administer about when an offense, a property offense, is against a person. So
I get that the jury didn't find he caused death. On the other hand, it did find either this dwelling or this putting a person in jeopardy was met. So we have to, and so I guess my question is, as to that, what the jury did find, dwelling or putting somebody in jeopardy through an offense against them for purposes of Section 7, against whom else were offenses committed other than
Well, like I said, I think there were
the
offenses.
conspiracy state, on his first counts 1 and 2.
Well, okay, I think it's possible, to the extent the jury found it was lives were put in danger, it easily could have been Libyan lives. Like I said, there were Blue Mountain guards around, there were February 17th guards around. And then to the extent it was about a dwelling, I think that even the government is not disputing that that is not against a person. It is against simply a building. It is not against a person. So it sounds like maybe I should turn to the instructional piece of this, which is that even if you disagree that an offense, under the statute, which is again is about buildings and entering buildings, the focus is all about buildings. If you think that that is an offense that actually
it doesn't focus all about buildings for purposes of this case, where you have the enhancement provision, right? It just doesn't seem fair to me to say that this was only about buildings when there was also a finding that either a dwelling was attacked or a person was put in jeopardy.
In that case, Your Honor,
it makes quite clear. I mean, to Judge Millett's point, it's not just a building. It says for destroying a building if the building be a dwelling, right? So you can't just revert to the fact that it was a building. There has to be, the statute makes clear that a dwelling is some particular type of building, right? A building, which in common law is defined as a place where a person lives.
I agree, Your Honor, but I still think linguistically it just sounds strange to say Mr. Abukhatallah was convicted of injuring a dwelling against a U.S. national. That just, I think you could certainly say that it harmed a U.S. national, or it harmed the interests of U.S. nationals. But the fact that Agent Ubin slept in this building for a limited period of time, I don't think it makes that offense against Agent Ubin, who wasn't present at the time this offense was committed. But even assuming you disagree with me, you think that this is an offense that can be committed against a person, the jury was not instructed about this element. And there is certainly a reasonable probability that if it had been, it would have found that this was not committed against Americans. As I explained in the brief, the jury's verdicts are best understood to mean that Mr. Abukhatallah joined this attack during only the second wave of the attack. That was, I think, around 11:43 is when that second wave begins. And the Americans had all evacuated by that point. There are only Libyans on the premises. So there's certainly a lot of reason to think that the jury might have found that he did not commit that crime against Americans.
When you say joined, do you mean that's when he personally appeared on the scene?
Right. Well, so I mean, to some extent, this requires us parsing the jury's verdicts, right? And the
I'm just asking what you meant in your theory that he wasn't there until what you're calling the second wave. I don't know if everyone agrees on which wave story when or how many waves there were. But when you said what you were saying about they must have thought he was only on the scene for the or only involved in the second wave. Are you saying that because that's when there was evidence that he was present? Because there's evidence that he was involved in the sense of trying to stop protective troops from coming in. You dispute it, but trying to stop protective troops from coming in. Testimonial evidence that he was there. Don't come in. Don't you harm us during the first wave. Which, if you're, right. I'm not going to call it first wave. During at the time when Americans were still there.
Yes, and to be clear, the reason I'm saying that he was convicted only of the second wave is because to reconcile the jury's verdicts with the facts, you would need to conclude what I said. If he was really involved at 10:20, then it's hard to see why he wouldn't be responsible for the deaths of Ambassador Stevens and Sean Smith. I mean, it's not entirely clear from the record, but they could well have been alive at that point. If he's stopping trucks from responding and telling people to stand down and not helping, the government argued to the jury, well, these stand down orders show that he let these people die. As I explained in the brief, I also think that evidence is quite equivocal and certainly not something that the jury relied on. If the jury relied on this Bilal al-Ubidi's testimony, it absolutely would not have would not have acquitted on any of these counts. I mean, Mr. Ubidi implicated Mr. Abukhatallah in all of these crimes. So I guess what I'm trying to say is that to understand the jury's verdicts, you would have to, or the best understanding of the jury's verdicts, and again, our burden is just to show, that there's a reasonable probability that the verdicts would have been different on this count. But the best reading, I think, of the jury's verdicts is that they concluded that Mr. Abukhatallah was not involved in that first wave, because that's when all of these deaths occurred, and they acquitted him.
Well,
of
they
all of these
acquitted
deaths.
him as to count 1 and 2, which are the material support counts. That's where they said it didn't result in death.
Well, there also counts 3, I believe 3 through 15 were all about these deaths. They were charging murder, attempted murder, destroying buildings that resulted in death, and they acquitted of all of those charges. So, Mr. Abukhatallah was charged in multiple counts for all of these murders, and the jury.
Yeah, they also. I mean, I guess. Yeah, and we're all struggling with this, but we do have to. We have to give weight. I get that, but we have to give weight to the fact that they did find him guilty, placing life in jeopardy.
Right. They either found him guilty of that or a dwelling. I mean, they weren't instructed that they needed to be unanimous. So, like I said, there was plenty of evidence in the record that the TOC was a dwelling. Like Judge Rao just mentioned, Agent Ubin slept there. They introduced a map of the building to show, this is his bedroom. Agent Ubin testified, this was my bedroom. Here's where it was. They certainly could have concluded it was a dwelling, and that's not at all inconsistent with the idea that Mr. Abukhatallah was involved in that second wave when he appeared on video, and when all these phone records showed he was having this 18-minute call with Al Imam and 16 calls between blah, blah, blah. And so, there's certainly a reason to believe that that's what the jury determined, and that if the jury had been told, you need to find that this was against an American, they would have said no. Americans were not there, no lives were placed in danger. And so we're not convicting on that count.
Right, but again, for Section 7, it's not lives in danger. It's just that there's an offense against an American.
Right, and my position is that if no Americans were present, then this is not an offense against an American. And the government is not arguing it remains an offense against an American simply because this was American property, or it remains an offense against an American simply because this was a dwelling that was, previously occupied by an American. The government's argument is this is an offense against an American because the jury probably found that lives were put in danger, and those lives were probably American lives. And my position is there's definitely a reasonable possibility that that's not right. That's really hard to reconcile with the verdicts.
Well, why is that? I mean, there's a lot of evidence that he was involved in planning the attacks. There's no evidence. There are different groups attacking the embassy at the same time, and he has his militia, and there's at least one other major militia there. And there's one big hole in the government's case, which is no one knows who inside the building set the fire that killed the ambassador. So the easy way to reconcile all of this is to say the jury found him involved in planning the attack, but they don't know whether his militia set the fire that killed the Americans.
I think that's possible. I think that's unlikely, number one, for 2 reasons. Number one, the government never argued that, and neither did the defense. So nobody before the jury ever identified the theory that yes, even if Mr. Abukhatallah were involved in planning, like for the defense did not say, even if you find Mr. Abukhatallah was involved in planning and you credit this testimony about, by these Libyan cooperators, you should acquit him because, we don't know who set this fire. No one ever identified that theory to the jury. So it's, I think, pretty unlikely.
They're not going to be making conditional arguments about what happens in the event of a partial acquittal. They're going to be building their case piece by piece, and a lot of the pieces here are the conspiracy evidence before the attack ever happened. He's a leader of the militia, and he's armed to the teeth. And
so maybe a better way of putting what I said is that the government argued that basically, regardless of who set the fires, Mr. Abukhatallah was responsible because he planned and coordinated with these people. And the defense did not disagree with that. So, we didn't say anything to suggest, okay, even if he was a member of this conspiracy with these people, well, there's this other militia over there that that they might have set the fire. So it'd just be very surprising for the jury to have come up with that on its own. But you are correct that this is actually a theory that Judge Cooper identified below as one possible reading of the verdicts.
Right.
And so I'm not saying it's absolutely logically impossible, but for the reason I gave, I think it's unlikely. And for a second reason, which is that the jury also didn't have any basis to conclude that the damage to the TOC, to the Tactical Operations Center, during the second wave of the attack was by Mr. Katala specifically. So why would they have convicted on any counts at all under that theory? I mean, no evidence was introduced that Mr. Katala, or we don't know exactly what the jury thought, who the jury thought was in his conspiracy, but there's really no evidence about who destroyed the TOC or who destroyed what building. So I think we can't say for sure, or it's very hard to apply that theory consistently throughout. But again, even assuming you're right, and this is I think it's a possible explanation, our burden is not to show that there's no reasonable possibility that the jury had a different.
No, you're right. You're right. There are two possible explanations for this. One is the one I posited and Judge Cooper posited below. The other is yours, which is he's not involved in anything until he just happens upon the embassy around 11:30 and decides on the spur of the moment to join the second wave of attacks. That's your.
I would say that the jury had a reason to separate out that second part of the attacks.
Sorry, did or did not?
Did have a reason to
Right.
separate out that second wave of the attacks because there was video of that. And the jury just clearly discredited an extraordinary amount of the evidence that your theory relies on. So for example, the planning, that relied on testimony of, for example, Bilal al-Ubidi, who
Relies
said,
on the cooperators, it
The
relies on
cooperators.
the phone records, it relies on the FBI testimony, and
Right.
it relies on the video, which is that when he shows up, he doesn't just walk in, he has his AK-47, right? Which is a little
Right.
hard to explain as he's just walking down the street and then gets caught up in the spur of the moment.
Well, right. He said right. We don't know exactly what caused him to be downtown or to be at the embassy. But to respond to your earlier point, I think the people the Libyan cooperators who implicated Mr. Katala in the attack gave testimony that I think was clearly rejected by the jury. One of the cooperators told the jury that Mr. Katala said, well, if it hadn't been for bin Hamid, I think his name was, I would have, who's the person who helped with the annex, helped the Americans get out from the annex and back to the airport. Well, if it hadn't been for him, I would have killed all of the Americans. I would have wanted to kill all the Americans. It's pretty hard to reconcile that with the fact that Mr. Katala was acquitted of all of the annex stuff. I mean, even if you think, someone else might have started the fire at the mission, well, the government's theory was still that Mr. Katala's pre-planning and all of that, and the fact that he supposedly got mortars from Bilal al-Bidi showed that he was heavily involved in the annex. Well, the jury rejected that as well. So I think,
But it's the same problem as the annex, which is there are multiple attackers and there's nothing specifically tying that mortar to him, just as there was nothing specifically tying the fire in the villa to his militia as opposed to the other militia that was there.
right. Well, count 15 of the indictment charged Mr. Katala with injuring a building at the annex. So not killing simply, but injuring a building, and he was acquitted of that. So I think it's quite clear that the jury thought that Mr. Katala was not involved at all in the annex, because what would it mean to even be involved in that attack and injure a building? Which again, I think is different with the mission attack because he was convicted of injuring a building there. So I think that again supports our narrative.
That's fair. That's fair. There is more tension. There is some tension in the cooperators' testimony with vis-a-vis the annex that is not present. To me, the villa part just breaks cleanly because the cooperators don't testify to who set the fire inside the building. So the acquittals on the Villa murders, to me, don't really undercut the cooperator's testimony. But you have a point about the annex.
Well, and if the jury did not credit the testimony as to the annex, which I believe all of the Libyan cooperators, implicated Mr. Khatallah in, there's no basis to believe that the jury credited these cooperators with respect to any of their testimony. And in fact, the judge didn't credit these witnesses' testimony for large parts of their testimony. I think the judge seems to have wholly discredited Khalid Abdullah's testimony and acknowledged that Bilal al-Bidi's testimony had enormous holes in it. For example, if you were to credit those telephone records and say that they're correct, and then there's a really pretty big tension between Bilal's statement that he had this 10-minute call with Mr. Khatallah, where Mr. Khatallah did all these things and issued this stand-down order, which basically allowed Ambassador Stevens to die because he was withholding aid or causing aid to not arrive. Well, how could he have that conversation in 37 seconds? That's just such a substantial difference. So I think, looking really closely at the record before the jury, there's just no way to say that there's not a reasonable chance, at least, that the jury would have concluded that this crime wasn't committed against an American because the Americans were gone at the time. If it makes sense, I'll move on to the last thing I'll talk about. So I wanted to talk about the prosecutorial misconduct here, which the government doesn't dispute occurred. So there's two kinds, both of which occurred during the government's rebuttal summation when Mr. Khatallah had no further opportunity to respond. First, the government deliberately inflamed the passions of the jury through its American Son speech, our American Son speech, even though the district court had specifically instructed the government not to say things like that. And then it attacked the reliability of defense stipulations as compared to live witness testimony, even though it knew that these stipulations were critical to the defense, and even though it knew that the defense was not able to present live witness testimony, even though it obviously would have preferred to, because of the government's own classified designations. This misconduct was unfair and it prejudiced Mr. Khatallah's trial.
Can you focus on the prejudice question? Because you said there's, since we know argument that this was completely improper and unprofessional conduct, not befitting the United States government by this prosecutor, especially after having already been told by the district court not to do it. But I think, alas, we have to turn to the prejudice inquiry.
Well, I guess I would say several things. The government seems to point to 4 different things. Number one, about why this wasn't prejudicial. Number one, did this go to a central issue in the case? Well, yes, for sure. I mean, both of these things, the defense stipulations were about who did this. And it certainly exculpates Mr. Khatallah, who's saying, I did not plan this. I was not involved in this attack, to have other people be reported to the government as having done this. And I just want to really highlight how much more helpful it would have been for the defense to be able to present live witness testimony. I mean, to read a stipulation in 10 seconds or 5 seconds saying, oh, a government agent has information that person 1 was involved in leading this attack is radically different from being able to put on a witness at trial and say, what did you learn? Who told you this? Did you believe them? What did you do any research to, and get to actually tell a story, introduce the evidence on your own terms. So starting out, there is a defense handicap here, a very significant one. And I'm not saying that that's improper because, we have to live with these classified procedures. But the fact that the government exploited it, I think, is just really beyond the pale. But to go back to the centrality of the issue, and the fact that Mr. Khatallah was, that other people supposedly led this attack and were involved in this attack is very important. And sorry, the other stipulations went to the credibility of the Libyan witnesses, which is obviously important in tying Mr. Khatallah to.
Sorry, I didn't hear the credibility of.
The credibility of the Libyan cooperators, and that also, of course, went to all of the acquitted counts as well as all of the convicted counts as well as acquitted counts. The next issue, let me just. The government also says that these are split verdicts and therefore there was no prejudice to Mr. Abukhatallah. And it's true that the court has in small recognized that split verdicts can sometimes suggest that prosecutorial misconduct didn't affect the jury. But I just don't think that that is applicable here, because here, unlike in small, the prosecutor's comments were not isolated to a particular set of counts on which he was acquitted. I think in small, it wasn't necessarily entirely isolated, but it largely went to one of the convictions. And there was overwhelming independent evidence of the defendant's guilt with respect to the other count. And that's just not true here. So I think, again, the evidence is very overlapping. The misconduct goes to the heart of everything. And I'm sorry, I forgot to say on the centrality of the issue with respect to the inflaming of the passions, the our government son's speech, that obviously goes to everything as well. This is a crime, and Mr. Abukhatallah is accused of terrorism, creating an us versus them mentality, making it clear that the jury's duty is to convict this foreigner is inflaming the passions of the jury. And certainly we can't say that part of the reason the jury convicted is because they didn't want to let this guy go entirely free. I mean, maybe honestly, the best way to explain why the jury acquitted is presumably because it discredited the vast majority of the evidence. It could be that if it had been able to rationally assess the evidence without this impassioned plea by the prosecutor, then maybe it would have acquitted on all counts. The judge's curative instructions, I think it's not that they were entirely unhelpful, and the court has recognized that curative instructions can be helpful. But the court has also recognized that simply saying, the arguments of counsel is not evidence is not enough. And the instruction that went to the stipulations wasn't really responsive to the problem, because the problem is elevating stipulations over live witness testimony and saying, well, if you had a live witness, then you really know whether you can believe them, but these stipulations you can't believe. So I think that is very, it really did not cure the problem. It is not coming to me what the final factor is, so I will try to address that on rebuttal.
Okay. My colleagues have any more questions for Mr. Abukhatallah's opening argument?
No, thank you.
Thank you.
Thank you very much. We really appreciate that your endurance and your presentation on those issues, and that will let the government both respond and then raise its affirmative argument as to sentencing.
Thank you, Your Honor. Good morning, and may it please the court. My name is Dan Lenners, and I represent the United States. If I might please reserve 2 minutes for rebuttal to address the government's sentencing appeal, I would appreciate the time. In fact, I would like to begin with that issue before we all run completely out of steam. The defendant is an unrepentant terrorist who participated in a world-renowned terrorist attack on a US diplomatic facility during which 4 Americans were killed, one of whom was a sitting ambassador. The district court's extraordinary variance from a guideline sentence of life to a mere 12-year sentence on the terrorism-related charges for which it had discretion was unacceptable and constituted a substantively unreasonable sentence. The judge said that this would be an easy sentencing, but for the jury's acquittals. And in focusing so much on the counts for which Abukhatallah was acquitted, the judge lost complete sight of the seriousness of the terrorist offenses for which he was convicted.
Okay, but just to be crystal clear, you don't dispute the district court's authority to vary down to avoid taking account of acquitted conduct.
That's correct.
Okay, and I want to clarify another thing. I think in your both briefs on the cross appeal, you argued that backing out the acquitted conduct gets us a 30 to life sentencing range. Is that right?
Yes, Your Honor.
Okay. And so had the district court sentenced to said, I'm going to back out the acquitted conduct, but sentenced to 30, 35, 30 years. And then you get the 10 additional years for the 924C count, if that were to stand, then you wouldn't have an argument about substantive unreasonableness.
I don't think we wouldn't have an argument about substantive unreasonableness. We'd have a much more difficult argument about substantive unreasonableness. But
Well, if you agree that the district court can back out the acquitted conduct, and I didn't double check your calculations, I'm taking your brief at its word, that creates a range. And so we'll just take, for these purposes, a sentencing range of 30. I realize we're getting there by variance, but that leaves, that's an aspect of variance you don't challenge. And so then we're in a 30 to life. Then you would still argue that it's substantively unreasonable because he had to count some of the acquitted conduct?
As I said, Your Honor, it'd be a much more difficult argument, but a guideline sentence can be substantively unreasonable under the facts of a case. The facts of this case are horrific. The defendant.
Can I just ask you a calculation point before you get into that? So if you back out the acquitted conduct, which is the causing death, by my calculation, you get a sentence, you get 30 years to life on the non-924C counts, and then plus 10. So it's really 40 to life.
Yes, Your Honor. And I understood Judge Millett to include the mandatory minimum.
Yeah, I just want to figure out if we're talking about 30 or 40. I was thinking of it as.
Sorry, I thought I said 30 and then you would get the 10 extra.
Right. So 40 total or more, taking account of the 924C.
Yes, Your Honor.
Okay. All right. Go ahead.
Right, so
And I'm sorry.
Right when I didn't mean when I said 30, but plus the 10, but you're right. So
I think
so
we're all on
gonna
the
do
same
total
page
sense
here.
of 40.
And I may have misheard you. I'm sorry.
And again, Your Honor, the court doesn't have to decide this issue. Whether the government would have a successful substantive unreasonableness argument to a 40-year sentence is not a bridge we have to cross at this point.
Well, no, but I was just, you were opening with this, the sentencing range of the sentencing guidelines led with the life imprisonment, but then you weren't challenging the backing out of the acquitted conduct, which gets us down. What I meant by 30 is that's the discretionary, there's no discretion over the 10 years. So in the discretionary area, we're down to 30. And so it seems to me that as to the discretionary aspect of the sentence, it's how do we get from 30 down to 12? Because again, the 22 came from adding the 10 on. So isn't that really where the focus of your argument? That's really where your argument is about, is how did we get down from 30 to 12? How did the district court get there?
If the court wants to look at it from life to 22 or life to 12 or 30 to 12, all of those are extraordinary variances. None of them are adequately explained by the district court's attempt to back out of acquitted conduct, and all result in a sentence that is substantively unreasonable on the horrific facts of this case.
Right. And then just to lay things out for you on how I'm trying to struggle through this issue, and that is, our standard of review is profoundly deferential, and there's no claim of any procedural error. I mean, Talbot tried it at one point, but you're not claiming any procedural error here. So you're really just attacking the discretionary judgment, which gets the most protection. And then this is not a case where the district court was skeletal in explanation. The district court here gave a lengthy, and I think you certainly have your arguments about disagreeing with it, but gave a very thoughtful and careful explanation of his sentencing reasoning here. And yet, as you point out, for the discretionary counts, 30 to 12 is a big jump. But the district court mentioned other factors besides the acquitted conduct, his age at the time he would come out of prison, and and I know you disagree about that, but that is a relevant factor for a district court to consider, his support, his employment history. So how does one write the opinion that you want that says that all of the factors, assuming we're backing out the acquitted conduct, that all of the other factors the district court mentioned don't justify, or not under, justify is not the right verb here, under our very deferential standard of review, as a matter of law, puts his judgment off limits. And I can't speak for my colleagues, but simply claiming terrorist doesn't do the work for me. I need really some sort of hard substantive analysis, which is not to dismiss what happened here, but grappling with the jury's verdict, the 4 counts, everything else that was acquitted. How do we describe, how would one write the opinion that says this was, as a matter of law, an off limits discretionary judgment?
There are a lot of questions there, Your Honor.
Sorry, you get to write the opinion right now, so have at it.
Starting with the fact that this was a thoughtful and reasoned opinion, that certainly hasn't stopped other courts from reversing on substantive unreasonableness grounds. In the Caesar case that we submitted as part of our 28J letter, Judge Weinstein, famed jurist, had what the court called a meticulous inquiry and analysis, and said it was, despite our admiration for that, the court nonetheless ended up in the wrong place. and that could equally describe what occurred here. In terms of the other factors that the district court discussed, first, the court discussed those before he said this would be an easy sentencing, but notwithstanding for the foregoing, this would be an easy sentencing, but for the acquitted conduct. So it seems clear that if the judge, it's unclear that the judge put any weight on those, but to the degree he did, it seems clear that he put minimal weight on them. And finally, even many aspects of the judge's analysis of those other factors betrayed the fact that he lost sight of how serious this offense was. Talking about Abukhatallah as though he's a sort of standard street criminal who's going to age out of crime, who has a supportive family at home, it completely ignores the fact that he is the leader, the self-admitted leader of an armed extremist militia in Libya who participated in a world-renowned terrorist attack on a U.S. diplomatic facility during which 4 Americans were killed. It's just like he was describing the type of criminals who come before him every day and lost sight of the seriousness of the offense, the significance of this crime of terror, this defendant's role within this armed extremist militia. I think that's how you write the opinion, saying that this extraordinary variance, which is requires a much more significant justification than a lesser variance, was not justified here, going from a guideline sentence of life to a discretionary sentence of 12 years, or even backing out acquitted conduct guidelines of 30 to a discretionary sentence of 12.
How do we reconcile? The district court had two sentencing rulings, the guideline calculation opinion, and then the actual sentence. And it just seems like they're more than a little bit schizophrenic on how the court reacted to those issues. Because even apart from acquitted conduct, the court says all of the things you were just saying in the first opinion, and I think maybe in the first half of delivering the actual sentence. He says, you're a hardened terrorist. You're a leader of this militia. This is an extraordinarily serious offense. It just seems hard to reconcile the first 75% of what he did with the last piece. And taking out acquitted conduct to go from life down to 40 or 30 plus 10, whatever it is, doesn't seem to account for all of that.
I agree, Your Honor, and I think you just described a substantively unreasonable sentence where the court seems to have described this defendant as a terrorist, as a leader of this horrific attack, and yet at the end makes this sort of U-turn and ends up in a cul-de-sac where, you know, he ends up imposing a substantively unreasonable sentence. And under those circumstances, it certainly seems appropriate to say that the extraordinary variance here was not justified by these reasons. It resulted in a sentence that does not accurately reflect the seriousness of this conduct.
Is it substantively unreasonable to disagree about recidivism risk? Disagree with the government about recidivism risk?
I don't know if that results in substantive unreasonableness
Do you
alone.
have evidence? Is there evidence about his likelihood of recidivism? Had he, and it's a little hard to compare because having been in Libyan jails, it's not quite the same thing to say whether you recidivate from that. But I mean, what was the evidence of recidivism other than his terrorism? His terroristic
I don't think
behavior pattern.
I apologize for interrupting, Your Honor. I don't think there was evidence either way. I mean, he put in evidence of his age.
Could it be substantively unreasonable? So it's, would you argue that it was substantively unreasonable to disagree on recidivism? And so as part of his 3553 analysis to include that as well?
I think it was a mistake the district court made in not recognizing the judgment that Congress and the sentencing guidelines have made that terrorists are different when it comes not only to the risk that they will commit a recidivist crime, but also the horrific consequences if they do. I also think that the district court failed to appreciate the fact that this defendant is going to go back to Libya in his mid-60s. If history is any guide, will be received as a hero when he does. And that's not only recidivism, but it also goes into, pointing out that the deterrence effect. I think many terrorists, if they could participate in a murderous attack on a US ambassador and, go home alive in their mid-60s, would welcome the opportunity. It's certainly not going to deter Abukhatallah specifically, nor other terrorists or the people who aid and abet them generally, to sentence this particular defendant, who was a leader of this attack, to only a 12-year discretionary term on the crimes for which the judge had such discretion.
Mr. Lenners, do you think it was a separate, I guess, kind of error or a separate reason for unreasonableness that the judge here seems to suggest, or he says quite explicitly that he thinks 22 years is appropriate as an overall sentence, and that if we were to reverse on the 924C count, that we should remand for resentencing, which suggests that he thinks that 12 years is not in fact adequate for the other three counts, which I don't know. To me, that seems like another, it's almost as though he's reducing the mandatory 10 years in terms of adding them on to the 12 years.
I think that's a fair way of looking at it, Your Honor. Certainly the Ninth Circuit in Rehearsal distinguished between the mandatory part of that defendant's sentence and the non-mandatory part in holding that the district court sentence there was substantively unreasonable. And it does seem here too that the district court was almost asking for a second chance to increase the sentence for the terrorism-related offenses based on this mandatory minimum, which does
suggest that 12 years is unreasonable without the mandatory minimum.
I agree with that, Your Honor. Yeah. If the court has no further questions about the government sentencing appeal, I'd like to turn to three of Abukhatallah's substantive arguments for reversal. And I'll just take them in the same order that the defense did. The defense's argument on the phone records largely ignores the statute, 18 U.S.C. 3505, which mandates that questions of admissibility of foreign business records such as these be determined before trial. But it also ignores the difference between self-authenticating records under Rule 902 of the Federal Rules of Evidence and non-self-authenticating documents and other evidence under Rule 901. Foreign business records such as these telephone records are a form of self-authenticating evidence where the document itself is all the evidence of authenticity necessary to establish the prima facie case to go to the jury. That's what Rule 902 says. These items require no extrinsic evidence of authenticity in order to be admitted.
I don't think they're challenging the district court's decision. This can go to the jury. What you just said is that still before the jury. There's round two, I guess. This is round two. Their argument is that you still had to give the jury an evidentiary basis for concluding that these were authentic telephonic records. And you didn't do that. And so it seems to me 3505 isn't speaking to that. It doesn't displace the jury's ability to decide, even if they were ever, I assume they're never even told about what the district court does, but to go, well, we think this is something my 12-year-old could have typed up on the computer. That's not displaced. And so you still had that burden. And I think that's where their argument is focused. And I'd like to hear your explanation as to why there was sufficient authentication evidence before the jury, unless you prefer just to not say we didn't have to do anything.
Well, my first answer is we didn't have to. The statute makes clear that this is a determination made by the judge before trial. So to the degree
was there a jury instruction, and did you ask for a jury instruction that would have advised them that they must accept these as authentic records?
No, Your Honor, and the jury was not required to accept these.
Exactly, it could decide that they're not what you claimed they were, right?
Yes, Your Honor.
That was, okay.
And the jury had that opportunity.
That was a jury issue. So it was an open issue before the jury whether these were what you said they were.
Correct, but
so you had to persuade the jury that they were what you said they were.
But they're saying
you had to correct. You had to persuade the jury that they were what you said they were.
Not in order to get them admitted, Your Honor.
I'm not talking about these met the threshold of a jury can see them, right? That's what 3505 is doing, right? This met that threshold, but you still had to convince the jury, if you wanted them to rely on them at all, that these are what you say they are. And you put on evidence to that effect. I don't understand your point. We didn't have to do anything. You have to convince the jury that these were what you said they were.
Your Honor, I want to be careful here that I think we understand each other. I think we're saying the same thing, but only in different ways. Mm-hmm. I understand the defendant's claim to be that these records were improperly admitted into evidence, that they should have been withdrawn and not given to the jury. That is, I think, wrong, and I think Your Honor thinks it's wrong based on the statute.
I understand that. I had understood her argument, which she described as a sufficiency of evidence argument, and that is that the district court was the gatekeeper that could go before the jury, but then you didn't do your job of allowing a jury, providing a basis for a jury to, and she can correct me if I've misunderstood her argument, to be clear, but at least as to this issue, did you provide a sufficient basis, sufficient evidence for a jury to conclude that these were what you said they were?
And I just to be clear, Your Honor, I think what she's saying is we didn't, and thus the record should not have been put before the jury. Mm-hmm. And that second part is wrong. Mm-hmm. That determination that they are put before the jury, the judge's gatekeeping roles in this instance by statute commanded to occur before trial. Mm-hmm. And so they were properly before the jury. Once they're before the jury, the government bears no burden of putting on additional evidence. Then it's just like any other piece of evidence that the parties can argue about the weight. And they argued that the jury should give these records, the telephone records, no weight. The government said you should believe that they are telephone records and you should give them heavy weight. And that was appropriately a decision given to the jury here because the government met its pretrial burden under Section 3505. In terms of what evidence established that they were phone records, we described this in our brief. The headings written in Arabic indicated time of call, duration of call, number calling, number called. There were other headings that indicated the cell phone towers that the calls pinged off of. There was testimony that the subscriber lived in Benghazi and was the defendant's brother, and that the defendant lived at the same address. There was testimony that the color that subscriber page was the same color as all other records from Libyana, the cell phone company. The guard from Libyana said he had seen similar, the same records in the same format in the past, not often, but he had seen them. And when asked whether he believed these were authentic or that these were Libyana records, he said for sure. The phone number, the area code, if you will, was 092. Which was specifically assigned to Libyana, the cell phone company. And so all of that evidence was before the jury for it to determine how much weight to assign these properly admitted records. But the government's argument is that they were properly admitted based on a pretrial determination made by the judge, and the defense doesn't challenge that pretrial determination. They're just saying that the government should have put on additional evidence at trial, or they shouldn't have been admitted. And that's inconsistent with the statute. And it's inconsistent with how self-authenticating records under Rule 902 work. The records themselves are the evidence of authenticity under Rule 902. If I might, if there are no further questions, move on to the defendant's challenge that Section 1363 isn't a crime of violence because it can be committed by conspiracy. It's a longstanding postulate of criminal law that substantive offense and a conspiracy to commit that offense are separate crimes with separate requirements. I mean, that goes back to Pinkerton. Callanan, the Supreme Court, addressed the Hobbs Act, which had almost the identical structure as this statute, and found that they were separate crimes. I don't think there's any.
You proposed a jury, and you joined with the defense in proposing a jury instruction that defined as the first element on the 1363 charge that there be either conspiracy or attempt or the substantive offense, or I think even aiding and abetting, right?
So if I might step back, if we're talking about the modified categorical approach, the court doesn't just look at the jury instructions to determine what Abukhatallah was charged with.
Has the government ever asked for a jury instruction in a case like in a 1363 case that says that backs out conspiracy as a separate? I said this is a separate crime.
I have no idea, Your Honor, what the government has ever done. I'm sorry. I've read all the 1363 cases I can find. Mm-hmm. It's certainly true that the government backed it out of the indictment. Abukhatallah was not indicted for conspiracy. He was indicted for the substantive offense. The indictment says nothing about conspiracy. Similarly,
but you agree that if the government wanted to use count 16 as the basis for finding a crime of violence, it was a mistake to define the element as substantive act or conspiracy?
Not necessarily, Your Honor, because that conspiracy language refers most naturally to Pinkerton.
It does. So suppose I think it doesn't.
Well, I'd like to make my best argument for why you should think that, Your Honor, which is before giving the substantive instructions, after giving the conspiracy instruction, the district court said for counts 3 through 18, the government can satisfy its burden of proof by showing that Mr. Abukhatallah committed the acts of the offense himself, or that he conspired with or aided and abetted others to do the same. I will instruct you later on co-conspirator and aiding and abetting liability. And then after he gave those counts 3 through 18 instructions, and that's on page 834 of the supplemental appendix, After he gave those substantive instructions, the court then gave the Pinkerton instruction that
Pinkerton
allowed.
instruction is at 5903 of the transcript, right, which is after all of the substantive counts, and is in a different, he goes through the substantive accounts, then he says, now I'm going to explain aiding and abetting and Pinkerton theory. He doesn't say Pinkerton, but aiding and abetting and Pinkerton theories, and he does that for several pages, but that's in a separate passage from the point within the instructions on count 16, in which he says, participated in a conspiracy to injure or destroy the building.
I don't disagree, Your Honor. I think first of all,
which it's just not a Pinkerton instruction because it doesn't require, that clause doesn't require the completed offense, and it does require a conspiracy focused on the object, which you don't need it. You only need foreseeability in Pinkerton, so it just doesn't parse that way.
With all due respect, Your Honor, I disagree. The defendant was not convicted of conspiracy to violate sections 1363. The jury never had to find the existence of an agreement, which is the sine qua non of conspiracy. The jury was not given conspiracy-related instructions under count 16, like it was with regard to count 1. And again,
I agree with you. That's the better reading of the instructions, no doubt, but it is a little bit muddled.
I think, Your Honor, that you are discounting too much the structure in which the court gave the instructions. It gave count 1, which was a conspiracy instruction, and gave conspiracy-related concepts.
Full conspiracy instructions, right.
It gave count 2, which charged the same offense as count 1, but as a substantive offense. And it included in the jury instructions a note saying that these are different offenses. It then preambled the rest of the substantive offenses by saying the defendant can be found guilty of any of these offenses, 3 through 18, either through conspiracy or aiding and abetting, which I'll explain later. He then gave 3 through 18 substantively, including count 16, and then he explained Pinkerton. So I do think that the reference to conspiracy in count 16, first of all, it didn't require the jury to find an agreement or any of the other substantive elements of conspiracy, but the jury would have naturally understood that as incorporating this, he may also be found guilty of conspiracy, which I'll explain later, and that explanation was Pinkerton.
I see what you're saying. But the other possibility is the jury is looking at count 16. It comes across this conspiracy clause. It looks like a little bit of a cipher, but let's say they're good textualists and they say, okay, what does conspiracy mean? And they look through the instructions and they find all of the elaboration of conspiracy in count 1, and they connect the dots that way.
I don't think that's possible, Your Honor, because if we're assuming that the jury,
I don't think it's likely, but tell me why it's not legally possible.
Because if we're assuming, first of all, the court has long held that we review jury instructions as a whole, and if this jury was reviewing these jury instructions as a whole and came across count 1, it would have seen the differences. It would have seen that count 1 requires an agreement and count 16 doesn't. It would have come across the preamble to counts 3 through 16 that said he can be convicted through conspiracy, which I'll explain later, and it would have gone to the Pinkerton instruction. And that's why whatever this legal demand for certainty is under Mathis and the Supreme Court's other crime of violence cases is satisfied here. I mean, certainly this defendant was not convicted of conspiracy to violate 1363. The court gave the substantive elements of the offense, the malicious, injuring a dwelling or placing the lives of a person in danger. All of those are the substantive elements. It describes
conspiring. It also said conspiring, a word they'd heard before.
true. And the most recent time they had heard that word was when the court said, "I'll explain conspiracy to you later." And then it went on to explain Pinkerton liability, which I don't think there's any disagreement that Pinkerton liability is a version of committing the substantive crime and thus the crime of violence.
Are there any cases on on what you do, how you do this modified categorical analysis where arguably different documents cut in different directions? So if we just had the indictment and the verdict form, it would be open and shut in your favor. But we also have these instructions which make this, let's just assume, it introduces some degree of messiness. So how do we balance? Do we just look at everything and say, was it legally certain, or are some documents more important than others? I haven't seen a case like this.
I couldn't find any cases on that, Your Honor. I likewise didn't see any cases in response to Judge Millett's question about how plain error interacts. The defendant saying he's not claiming that this jury instruction was incorrect, but I mean, it was insofar as conspiracy to commit an offense and the substantive crime are different. And to the degree that this uncertainty or messiness, as Your Honor had it, was introduced, it was through jury instructions, proposed by the defendant.
Proposed by you, which said there's a single element here too. I really don't think this is the time to be pointing fingers. You signed off on a jury instruction that said the first element, and then combined all of those things together, which sounds like it's different means of accomplishing a single element.
We didn't disagree with the instructions the defendant proposed, Your Honor. That's true. They were proposed as the defendant's jury instructions, which is something the district court can certainly give weight to when evaluating them. But at the end of the day—
I'm sorry, the government signed off on them, didn't object. So these are fine with us?
The government, there was a footnote in the defendant's submission that said that the parties had met and largely agreed, and the government would talk about its disagreements later, and it didn't disagree with this language. That's true.
Right. So the district court understood this as both parties signing off on this instruction. It just seems to me this is, I can only speak for myself, but this is not the place for you to be pointing fingers.
Even if that's so, Your Honor, the first of all, we don't think that any messiness undermines the ultimate conclusion that the jury that Katsas was charged with and convicted of the substantive 1363 offense, and which is a crime of violence for purposes of 924C.
Is the government making any kind of plain error argument here? I mean, do you think that the specific argument that's being brought here with respect to conspiracy was forfeited below?
We didn't argue that, Your Honor. It's hard to sort of parse that out. The defense, whether you want to call it jointly or on its own, proposed these instructions. They did not object to this language. So at the very least, it's reviewed for plain error. And we did make a plain error argument as to the part of the 924C instruction that said counts 1 through 17 can constitute crimes of violence. The defendant did argue post-trial that he was not properly convicted of a crime of violence. And the defendant specifically did not make the conspiracy argument that he makes now. The Judge Cooper discussed that in a lengthy footnote in which he cited one of Judge Millett's, I think, concurring opinions, but specifically noted
the law changed.
Right.
The law had changed, I believe, by the time the defense submitted that. By the time the defense submitted that post-trial motion, the Supreme Court has not said that conspiracy, to my knowledge, has not said that conspiracy cannot constitute a crime of violence. The government isn't challenging that here. Yeah, we have conceded in other cases that conspiracy does not constitute a crime of violence.
Conceded here as well?
Yes, Your Honor. But the law had changed by the time the defense made that motion, and they didn't challenge conspiracy. It does seem that to the degree that whether you call it invited error or plain error are equitable doctrines, a plain error is optional. It's something the court recognizes as a matter of discretion. It does seem like the defense bears some culpability for introducing any messiness to this jury instruction that would educate the court's decision about whether to recognize a plain error.
I think that the government is making an invited error argument, though. I mean, is there any evidence that there was any kind of strategic purpose here that the defense had in making the jury instruction in this form?
With regard to this issue, no. The special maritime and territorial jurisdiction argument, I think there is some evidence of strategic or intentional decision. But with regard to the addition of the conspiracy language, I can't think of any reason why the defense would have added that. Although you can certainly understand why they wouldn't have objected to it when it naturally refers to Pinkerton. And where the government, there is some pretrial discussion, and I haven't read it fully, but there was some pretrial discussion about how the government wanted the aiding and abetting and Pinkerton language in every substantive instruction. And Judge Cooper said, no, I'm not going to do that. Rather, I'm going to give this preamble and then give those instructions after. And so it may be that this is the one instance in which the conspiracy language wasn't taken out where it was taken out elsewhere. If there are no further questions on this issue, the last issue I would like to address is whether.
I'm sorry, can I back you up and ask? I apologize. One other thing. I'm sorry. Are you going to turn to the against an American, the Section 7 issue? Is that where you're going?
I was going to, Your Honor.
Please go ahead. That's fine. That's fine. That'll work.
Thank you. The defense makes two arguments. There's the statutory argument that 1363 can't be committed against an American, and then the jury instruction issue. I don't have a whole lot to add to the argument I made in the briefs about the fact that 1363, particularly the aggravated offense, which requires the destruction of a dwelling or a person's life be placed in danger, can be committed against an American, which seems clearly to be a fact-specific determination, like many of the other offense-specific determinations required under Section 7 for a crime to occur within the special maritime and territorial jurisdiction of the United States. Assuming that's correct, it's true that the jury was not specifically required to find that this was an offense committed against an American. We argued that the defense invited that error by proposing the instruction, but this doesn't turn on invited error versus plain error under either standard. The defense
invited error, this is a jurisdictional element. Has this court ever applied the invited error doctrine to determine whether there's a jurisdictional element was satisfied?
Not that I'm aware of, Your Honor.
Do you have any court that has applied invited error doctrine to a jurisdictional element that has to be satisfied?
I haven't focused on that issue, Your Honor, so I don't know.
And this seems rather material, right? It's
in some respects, jurisdictional elements, I think, Your Honor, are in fact less material than the elements of the substantive crime. I mean, the Supreme Court said in Torres versus Lynch that the mens rea of the substantive crime doesn't apply to jurisdictional elements. And
that doesn't mean it's less important that actual jurisdiction for a district court to enter a judgment on a particular count be established.
I disagree, Your Honor. And the jury here found the factual part of the jurisdictional element that this occurred on, on a U.S. special mission effectively as shorthand. And they found
I don't know
that
what you mean by found a special mission as shorthand. That doesn't get you jurisdiction under Section 7. It has to be a special mission. And if there is an offense against an American, then special missions are within, or embassies are within the special jurisdiction. I don't know why Congress wrote it that way, but it wrote it that way.
I agree, Your Honor. And if the court doesn't want to apply,
So finding that it was a special mission is not code for finding that there was an offense against an American.
I didn't mean to suggest that, Your Honor, and I apologize if my argument did. We aren't disputing for purposes of this appeal that the jury needed to find that this offense was committed against an American and was not charged with that element. Your Honor asked if the court has ever applied invited error to jurisdictional elements, not that I'm aware of. Regardless, this case doesn't rise and fall on invited error because the defendant cannot meet the plain error requirements, which undoubtedly do apply if invited error does not. First of all, the special maritime and territorial jurisdiction of the United States it has lots of elements that are facts to be decided by the jury, but many of the sections of that code require legal findings or allow for legal findings by the judge. Under prong 2, whether this error was plain, it's not entirely clear. It's certainly not plain that whether the offense was committed by or against an American is a jury decision versus a judge decision. And there's no case that I'm aware of saying that this is something that must be decided by the jury. So the error wasn't plain under prong 2.
Well, how do we know when jurisdictional elements are submitted to juries and when they aren't?
The Second Circuit, Your Honor, has discussed this extensively. One case that I could point the court
Is the
to.
United States position on how, is it the United States position that this doesn't go to the jury? This against an American?
We haven't taken a position on that one way or the other.
Now's the time to take a position.
Well, that would go
You're
to
arguing that it doesn't have to go, and I want to make sure that's a position of the United States for all cases, that this doesn't go to the jury.
I'm sorry, Your Honor, we aren't arguing that it doesn't go to the jury. We're arguing that the law is not currently clear that it must go to the jury. That is not plain error. It might be error. This might be.
Why would it not go to the jury? Isn't it an element of the offense?
So under the special maritime and territorial jurisdiction, there are facts such as the location of the offense that go to the jury, and that there are also questions of law as to whether that location falls within the special maritime and territorial jurisdiction. And so under Section 7 writ large, there are some factual questions for the jury and some legal questions for the judge.
Right, but the question, your theory, as I understand it, is that the jurisdictional element is satisfied in a case where, at least if the jury finds that the life of an American was placed in jeopardy.
Yes, Your Honor.
Right, and I'm not sure your position on dwelling, but let's just take life of any person for now. I mean, that's a finding of fact. That's not a legal question about the scope of Section 1363 or Section 7.
Well, that satisfies the against an American requirement, but the ultimate requirement is that it be an offense.
How does it do that when it's defined as any person?
I think that's a jury instruction. Do I understand? Is that a question about the jury instructions, Your Honor, or a question about how
you said that satisfies it, but when 1363 asks about life of any person being placed in jeopardy, and yet the jurisdictional requirement is finding that there was an offense against an American, and those do not strike me as the same inquiry at all. They could, I mean, one could satisfy both prongs with a particular determination, but simply asking whether any person's life is in jeopardy, which I thought you were saying, would satisfy the jurisdictional element that there be an offense against an American.
I think I'm saying the same thing as Your Honor, that what the same evidence could satisfy both, but doesn't have to satisfy
And
both.
so if the evidence is disputed, if there's factual disputes about that evidence, that would have to be resolved by a jury.
Or there's a legal question about whether the offense was committed by or against an American, and the question for the jury is where the offense occurred.
Why is it illegal a question whether an offense is committed against an American? Maybe whether something counts as an offense would be a legal question, but whether it's against an American or whether an American, why would against an American be a legal question?
So I ultimately agree that it's likely a factual question for the jury, whether the offense is committed against an American, but that error was not.
What is the legal test? All right, was there, you're making a plain error argument, but if there's a settled legal test for determining what goes to a jury, and that settled legal test would clearly put a dispute over whether an American was, an offense was committed against an American, that factual question, against whom were offenses committed to a jury, then it seems to me it may be plain error.
I am not aware of a settled legal definition of when an offense is committed against an American, or a settled legal test for when you parse the legal questions under the special maritime and territorial jurisdiction from the factual questions.
Just jurisdictional elements generally in crimes.
That's true, Your Honor, and the jury often finds that.
Whether a gun moved in interstate commerce. Don't juries decide whether it moved in interstate commerce?
They do, Your Honor, but again, the special maritime and territorial jurisdiction, the Second Circuit has taken judicial notice on appeal of the fact that a crime occurred within the jurisdiction where the jury found as a matter of fact that it was located, say, in a jail. And so what constitutes a legal
right, but the problem here is that were the facts found, right? This isn't categorizing facts. For example, I guess if there were a dispute about someone's legal status as an American, they found it that there was an offense against X, and then there was just a legal dispute about that person's status as an American. Maybe that would go to the court. But here, it's just all a factual dispute about was an offense committed against an American. Not against America, not against an agency of the United States government, but against an individual American.
The court may think that's logically true, but there's no legal authority demanding that be the case for prong 2 of plain error. No Supreme Court case, no interpretation of the section that I'm aware of that makes it clear for purposes of plain error prong 2 that the district court had to give.
Because there would be a plausible argument in this case that the court could have decided as a matter of law. But there is there a colorable, not just plausible, is there a colorable argument that the judge could have taken that issue away from the jury in this case?
Again, Your Honor, ultimately, I do think it's a factual question for the jury.
But is there a colorable argument? You say it's not plain, which means there's got to be something open, because you can have plain error. You don't have to have precedent. A statute can be crystal clear. And so tell me how this one is not, as to this question, an American who was on the receiving end of an offense here.
The most I am prepared to point to today, Your Honor, is the fact that other circuits have routinely divided between legal questions and factual questions for purposes.
Of course, but yes, but not on, but you don't have a plausible, even a colorable or articulable argument as to how this could not have been a jury question here.
So by
whether the text of the statute,
whether something committed by an American is something that could plausibly be a legal determination. Someone's nationality could be a legal determination for the judge, whether the person meets the requirements of the Nationality Act cited in Section 7(9). And so the colorable legal argument would be that as a matter of statutory interpretation, the phrase right next to it, or against an American, is likewise a legal determination for the judge rather than a factual determination for the jury.
Okay.
So moving past, if Judge Millett's done with the judge-jury question, moving past that, can I ask you, just as a matter of substantive law, you think it is sufficient if someone finds, if it is determined that the life of some person was placed in jeopardy and that person was an American?
Yes, Your Honor, that would satisfy.
Is it also sufficient in your view if it is found that the injured building was a dwelling and it was a dwelling of an American?
We didn't make that argument in the brief, Your Honor, but it certainly seems like it would be sufficient. That
but if you didn't make it in the brief, then we're probably left parsing. It's another one of these issues in this case about did the jury, or would a properly instructed jury have rested on a dwelling theory or a life in jeopardy theory?
I'm sorry, Judge Katsas,
Right.
I was getting you, Judge Katsas, you were breaking up on that last sentence.
Oh,
You have what? Sorry.
I mean, if the government hasn't preserved the argument that you win if under the possibility that the dwelling of an American was injured, then don't we have to figure out whether the jury likely rested or could have rested on the dwelling theory or the life in jeopardy theory?
On plain error, Your Honor, it's not clear.
Assuming a plain error on prong two.
Assuming a plain error on prong two, and assuming that this court is on plain error review, it's not clear to me that the court is constrained to disregard if it thinks that a dwelling, injury of a dwelling where an American sleeps is a crime committed against an American. But the court need not wrestle with that issue because the defense cannot meet its burden of showing a reasonable probability of a different outcome had the jury been required to find that the life of an American was placed in danger. Lives of Americans were placed in danger throughout the entire attack. It's true, Judge Millett, that there were Libyans on scene. There were Blue Mountain Guards who were unarmed, who were injured during the attack. One was assaulted by militants. It's also true that there were 17 February fighters stationed at the mission who were assaulted during the attack. But coextensively with those assaults, Americans' lives were placed in danger. And so there's no reasonable probability, there's just zero chance that the jury found that the defendant was guilty of this crime because he placed Libyans' lives in danger as opposed to Americans. Factually, that's...
Well, why is that when we try to reconcile it with, and this is what makes these things hard, we have to reconcile it with the jury's findings that, at least as counts 1 and 2, his conspiratorial actions were not responsible for death.
Yes, Your Honor, I agree. I'm just saying that with regard to
just help me reconcile that.
Your Honor, I think there are two ways that make sense that are likely what the jury did, both of which would mean that the defense fails on prong 3. One is, as Judge Katsas noted, that there was no evidence as to who set the fires that ultimately killed Sean Smith and Ambassador Stevens and attempted to murder Agent Wickland. There was ample evidence of multiple militias and militia leaders on the scene at that time. And the Pinkerton conspiracy theory required that Katalase co-conspirators be the ones who commit the crime. And so as Judge Cooper found during sentencing, one very plausible explanation of the verdict is that the jury found that Katala was involved in this attack from beginning to end, but because of this hole in the government's case as to who set the fires, and again, the fires appear to have been set by happenstance. They were set with diesel fuel, and there was evidence that that diesel fuel was found on site at this Blue Mountain Guards, they call them the Quick Response Force, QRF facility, and that the militants used the diesel fuel they found there to light both that facility on fire and Villa C. And so there was evidence that this was a crime of opportunity. No one knew who committed it. And so the jury may have both found that there was not evidence beyond a reasonable doubt that Katala's co-conspirators lit the fires, or that the fires were reasonably foreseeable as a result of the conspiracy that he entered. The second also plausible explanation is that the jury used Katala's own words to conclude that he joined the attack in the middle. He himself said that he went to the special mission. He himself admitted that he had a phone call with one of the leaders of the 17th February militia, where he commanded him to stop shooting at us. If you kill one of us, you will be in trouble. He himself admitted that he had the call with Al-Ubaidi, that Al-Ubaidi described as Katala saying, stop, withdraw your men. He said that he manned what he called a roadblock, during which he turned away first responders, Libyan police. All of these things occurred in this interim period after the fires were set, which was approximately 10:03 p.m. There's evidence that there was smoke seen coming from Villa C at 10:03. After that, and thus after the murders were effectively committed, but before Katala was seen on video at 10:54. During that time, after 10:03, there were additional attacks on the Americans at the special mission that both destroyed property and put their lives in danger. If you're parsing out the timeline, the Americans were there at around between 11 and 11:15 p.m., during which militants started shooting back into the special mission. The Americans who fled the mission at 11:15, the State Department security personnel, came under fire. And also the GRS responders who were in Villa C still looking for the ambassador testified that the villa was struck by a rocket-propelled grenade, and that would have been around 11:19 or 11:20. There was ample evidence, overwhelming evidence that that Americans came under attack, their lives were placed in jeopardy after the defendant became involved in the conspiracy. And again, the flip side.
Sorry, just can I ask one thing? Is preventing aid from stopping forces that were going to try and reinforce the mission, preventing them from getting there, would that be in a form of an offense against an American? So the Americans are there, they're under fire, they're endangered. And his efforts to stop, the jury found his efforts to stop reinforcements, people who could protect and save them from getting there. I'm just curious.
I hadn't thought of that question. It's certainly a form of aiding and abetting, and it's a form of conspiracy liability. It adds to conspiracy liability, whether it's its own offense against an American. I mean, it certainly contributed to the Americans' risk from the attack from the militants outside who were shooting in, and their inability to be protected by these first responders.
Sorry, I didn't mean to interrupt. I just was trying to think that through.
I just wanted to, the flip side of it, what Katala has proposed is that he just inexplicably shows up with an AK-47 at 11:54 at night, leading his troops with Al-Imam, with Dajawi. Dajawi had been part of the first wave of the attack on video at 9:45 p.m. Al-Imam, he had this 18-minute call that ended at 11:02 p.m. He's just inexplicably shows up with these men, appearing to lead his troops. This "follow me" sign he gives as they leave, with and that the jury, based on that alone, found him culpable of conspiracy, providing material support, and destroying the special mission, and that based on that alone, they found him guilty because the talk was a dwelling. It's true that there was extraordinarily brief testimony by Agent Ubben that he slept there and maps of the talk introduced, but throughout that was not discussed at closing at all, like not mentioned a single time by either party. And second, the testimony throughout trial focused on the talks status as an office. It was the secured office that contained highly sensitive documents and computers. It was where Agent Henderson was staged throughout the attack, watching the attack on camera as it unfolded in the secured office. And they routinely called it the Tactical Operations Center or the office. Unlike, say, Villa C, where they described the bedrooms where Ambassador Stevens and Sean Smith were asleep at the time they were murdered, the bedrooms in Villa B, where several of the agents took shelter during this attack, there's just no chance whatsoever that the jury convicted Abukhatallah on count 16 based on a finding that he randomly joined this conspiracy at 11:54 p.m. and that the talk is guilty because the talk was a dwelling, not because he joined earlier and put Americans' lives in danger. And thus the defendant cannot meet his burden on prong 3. And then finally, on prong 4, whether there's a miscarriage of justice that the court should recognize.
I'm sorry, just one more thing I wanted to clear up. Even if the initial assault on the dwellings, was before at least Mr. Abukhatallah was physically on the scene of the mission, do we know whether there was continued, I don't know what it means to injure a building, but continued injury to those dwellings of villas afterwards, or were they already sort of burned to the ground at that point?
So the building is inside the special mission was Villa C that was lit on fire. There was this separate building where the quick response force lived that no one was particularly focused on. It was burned to the ground. That I think was a smoldering.
Do we know that it was burned to the ground before Abukhatallah was physically on the scene? I'm sure even if you don't start the fire, you could still, I assume, damage or injure a building by either preventing a fire from being put out or contributing, throwing more fuel on the fire or something like that.
So I don't recall what the status of.
There wasn't evidence like that before the jury.
There's none of this was discussed before the jury.
Mm-hmm.
As far as Villa C goes, there was extensive evidence that it was still on fire throughout the course of the attack. It was not burned to the ground. Mm-hmm. All of the agents on scene made multiple attempts at extraordinary risk to their own lives to find Sean Smith and Ambassador Stevens. Alec Henderson, Agent Wickland went in 4 or 5 times, almost passing out and dying in an attempt to rescue Sean Smith and Ambassador Stevens. The other agents also made multiple attempts. And the testimony was that the building was incredibly hot, on fire. There was this incredibly thick smoke. So yes, the building was smoldering, I think, or on fire throughout the course of the attack. But again, I don't think any reasonable understanding of the jury verdict would find that Abukhatallah somehow contributed to the destruction of the dwelling without putting Americans' lives at risk by preventing them from putting the fire out. I mean, if he joined this assault after the fires were set, after which Americans' lives were put at risk, or after which the building continued to burn, Americans' lives were at risk at that time because they kept trying to go into the building to save to find Ambassador Stevens and Sean Smith.
Is an attack on, I mean, I mentioned my home earlier, but if there's an attack on a governmental building that is a dwelling, a barracks or something like that, is that an offense against an individual American? Because it's not there. It's not like I own my, own my home. That would be offense against me. But I don't know if we would consider it an offense against an American to attack government. Someone attacks a prison or something where people obviously live, but there's nobody there. It's just been built, but there's nobody there. That would be an offense against someone who's about to move in.
I don't know the answer to that, Your Honor. The facts establish that some of these bedrooms, Ambassador Smith's, for example, or Ambassador Stevens, was not his permanent bedroom. He was visiting the mission and was there for a week. Others, like Sean Smith, were on temporary duty assignment and were permanently stationed at the mission. And this was his bedroom where he lived.
Right, but is a destruction of it an offense against, I don't know that it would be a crime against the individual since they don't own it, they're assigned there to that dwelling by the government.
I-
I mean, if they're there, it could be an offense against them if they're under your theory of this was about their lives being in jeopardy, for sure. I'm just talking about the dwelling issue.
And it destroys their belongings that are presumably in their bedroom. I mean, it's an offense against their own property.
That would apply to for some reason, the statute carves out dwelling because an attack on an office building is going to destroy people's personal possessions as well. So there's something about dwellings that Congress thought was different.
But again, that's the separate statute. So 1363 may be focused on protecting dwellings and lives.
Yeah, I'm just trying to figure out if we thought for some reason that with the jury, or if we couldn't foreclose the possibility, a reasonable possibility that the jury focused on dwelling here rather than the lives and any life in jeopardy prong, whether you could still say that would satisfy the against an American prong for the jurisdictional purposes. I don't know if it would be an offense against an American.
I understand, Your Honor, and it's been a long argument, and I'm not sure I'm prepared to
No, it's okay.
address that question at this point.
Okay.
I think it's fair to say that there's no reasonable probability that the jury here found this prong, that a dwelling or a life put in danger, but would not have found that the offense was committed against an American. For all of the factual reasons I've discussed about all the times during the course of this offense when Americans' lives were placed in jeopardy. And if there are no further questions, we would ask that the judgment be affirmed and the sentence be vacated.
Questions from my colleagues? Okay. Thank you very much. We will let Sheketoff talk about both a rebuttal on her arguments and respond to the sentencing argument.
If I may, I'll just start where we just left off to keep everyone's train of thought straight. I want to make just two forfeiture points. The government has said maybe the jury didn't have to find this against American element at all. And maybe, in response to Judge Katsas and Judge Millett's questions, maybe against a dwelling really is against an American, but that's not in their briefs anywhere. These arguments are forfeited. I don't think that's a proper basis for the court to make a resolution on this question. I think the government might also have been alluding to a miscarriage of justice prong 4 issue, but again, that's also not in their briefs, and so I don't see how this court can resolve this question on that ground. In terms of whose lives were put in danger, or actually, let me take a step back. I would also just want to address or reiterate the applicable standard here. Our role is not to be able to show that beyond doubt or extremely likely or whatever the jury found XYZ. Our job is to say, is there any reasonable probability that the jury would have reached a different outcome had they been instructed that they had to find that American lives were put in danger? And I think just the fact that they could have found a dwelling is what caused the aggravated offense, and the government doesn't dispute that that's not against an American. Just that alone is going to meet the standard. But again, we've given an extensive discussion of the facts about why we think that the best reading of the jury's verdicts are to conclude that Mr. Abukhatallah joined after the first wave of the attack had ended and when the second wave had begun after all the Americans had left. Whose lives could have been put in danger? Well, as we said, if it wasn't a dwelling, and that's not what the jury concluded, although I think that is the best reading of the jury's verdicts. Well, in addition to the guards, there were also everyone there. I mean, we saw, for example, Dijawi pouring gasoline on mission vehicles, supposedly Dijawi. That puts lives in danger. Often in these conspiracy cases, you have vicarious liability for a bystander being shot or someone else in a conspirator being shot. There's nothing crazy to think, or nothing crazy about thinking that the jury might have concluded that the militants' own lives were put in danger. So there are lots of options here that wouldn't that don't allow the government to show that there's that don't foreclose the possibility that there's a reasonable probability that the jury would have reached a different verdict if it hadn't been for this missed instruction. I wanted to just address quickly some of the facts that the government brought out. The government said that Mr. Abukhatallah admitted to a call with the February 17 commander with Bilal al-Ubidi into manning roadblocks. And that shows that maybe he joined the attack before all the Americans left. Well, if the jury credited all of that testimony, then it's really hard to understand why they wouldn't have convicted him of the murders, because the government's theory at trial was that by issuing these, quote unquote, stand down orders and by, manning this quote unquote roadblock and turning away first responders, that caused the deaths of Ambassador Stevens and John Smith, because help would have been rendered sooner if not for that conduct. The government also says, around 11:10 or 11:15, Americans came under fire. So that's after the first wave of the attack commenced, but before the second wave of the attack commenced. And Americans were still there then. Well, there's no evidence that anyone involved in Mr. Abukhatallah's circle or his alleged group of co-conspirators are the ones who pulled the trigger there. So if the government's theory is, well, the only reason the jury didn't convict on, counts 3 through 15 is because we don't know who set the fire. Well, the same logic would go here or would apply here. We don't know who pulled the trigger. So why would the jury have concluded, that Mr. Abukhatallah's conspirators pulled the trigger? But I guess stepping back again, that's just not a theory that was ever discussed before the jury. The government didn't discuss it. The defense didn't discuss it. And so there's really, while it's logically possible the jury reached the verdicts it did on that theory, it's not particularly likely, and it's not particularly even plausible given the absence of any argument about this. And it's certainly not plausible or so compelling that there's not a reasonable probability to think that that's not the basis that they reached their verdicts on. Judge, just last thing, Judge Millett asked, is stopping aid an offense against an American? I think sort of an antecedent issue is, well, even if it were, the jury acquitted of that effectively, right? On the theory that I mentioned earlier, which is that if Mr. Abukhatallah indeed had this call with Bilal at 11:10 saying, withdraw your men, and he was stopping aid left and right, it's just completely unclear how they possibly could have acquitted Mr. Abukhatallah of the first of the murders, because the government's theory was, the stand down orders and this interference with first aid is what contributed to these deaths, and the government just acknowledged on an aiding and abetting theory, he would be responsible. So I don't think that that's what the jury likely concluded. And there's lots of reasons.
An offense against an American for purposes of Section 7, I assume would include conspiring to harm them, even if you don't, for purposes of counts 1 and 2, even if you don't actually succeed because someone else did it before you got there. We don't know that it was you that did it, it was someone else did it. But the conspiracy itself, I would think, would be for counts 1 and 2. Would that not be an offense against an American?
I think maybe it could, but the point is that that the best understanding of the jury's verdict is that he joined the conspiracy after all Americans had left, and so there's just no way to rule out the probability or the possibility that the jury did not believe that he conspired to harm Americans, or that his conspiracy was targeting Americans, or sorry, that he conspired to injure Americans. That when he joined the conspiracy, injuring Americans was on the table, or was the goal.
So I'm having trouble hearing your last sentence.
I'm sorry, that that at the time that he joined the conspiracy, that injuring Americans was on the table, because at that time they had all left. I don't think that there's any theory that he joined the conspiracy at 11:43 p.m. intending to injure Americans and then was
he joined the
because
conspiracy in advance, the material support counts, and they were getting the guns and organizing this whole thing. And then, there were lots of militias in Libya at the time, and more than one militia there on the ground of the mission. And so couldn't they have found, if they found that conspiracy in count 1 and 2, doesn't that suggest that it would have been a basis under 1363 for having found that, or for bringing in Section 7 into 1363, the jurisdictional element, that there would have been an offense against an American, even if they, at the end of the day, the jury couldn't find beyond a reasonable doubt that they actually were responsible for the murders that happened?
No, I don't think so. I think maybe what you're getting at is Judge Katsas' theory that the one way to read the verdicts is that his convictions on count 1, 2, 16, and 18 did assume that he participated in, the first wave of the attack, and just other attackers are the ones that set the fire. And my view is that, yes, that is a logically possible way of reading the verdicts, but the best way by far of how to understand the verdicts is that counts 1, 2, 16, and 18 are all premised on his conduct starting at 1143.
Right. I'm asking the predicate section 7 question, not gets wrapped up in 1363, but just as the section 7 jurisdictional question. If there could be a conspiracy would be an offense against an American for purposes of section 7, even if at the end of the day, that conspiracy, the jury didn't find that conspiracy is the one that actually resulted in physical harm to Americans, but they still have an offense against an American just by conspiring to harm them.
But he was acquitted of that conspiracy. My view.
Well, if you think of the material support.
Right, and the material support, he was acquitted of causing death. And so my understanding.
That doesn't, offense against an American doesn't require death.
Right, I agree, but I would understand the acquittal of causing death to mean that he was acquitted of providing material support during the first wave of the attack, i.e. when there were Americans present, because you could not acquit of causing death, in my view, or it's highly unlikely the jury would have acquitted of causing death if he provided material support.
Could have conspired to cause harm. They could have found they did a conspiracy and the conspiracy caused harm, which would be an offense against an American.
But no, I mean, yes, but to acquit, I guess what I'm trying to say is, yes, I agree.
Acquitting on death doesn't mean you've acquitted on harm.
Well, I guess here
Americans that were injured but did not die here.
Right. I guess here I would disagree on the facts. I agree with you in the abstract. What you're saying is completely right. I just think here on the factual record before the jury, there is no way to acquit Mr. Abukhatallah of causing death, but yet nonetheless think he harmed Ambassador Stevens or threatened harm to Sean Smith, because if there was no distinction, the fires were set and they died. So if he had any contribution to that, then, he's responsible for their deaths under the Pinkerton conspirator liability theory. So what I'm trying to suggest is that the best way to parse these verdicts, to understand these verdicts, is that the jury, the only sort of rational or reasonable or most plausible, at least, way to understand these verdicts is that the jury concluded that he was, guilty beyond a reasonable doubt only for stuff that occurred once he was captured on video. And that is after all the Americans left the premises. There are no further questions on that. I would move to the spreadsheet issue.
And let's go quickly on your other affirmative arguments, because it would be a long rebuttal otherwise. But the point of a lot of the time here is to let you make an affirmative argument about the cross appeal. So you can
go to the cross appeal first.
You can make a quick comment as you wanted, I guess, about the telephone records. But.
I'm happy to do it in whatever. I can try to do the spreadsheet and the crime of violence very quickly if that would work for you. Okay, on the spreadsheet, the government raised two arguments, or raised the argument about, well, this is a self-authenticating record, and so you just need to put it before the jury. The statute is quite clear that what authenticates the record is the certification, and that was not before the jury. So it's just not self-authenticating without that certification. There's absolutely no law suggesting that the fact that you have a certification that you've previously shown it to the judge renders the records that are supposed to be accompanied by the certification themselves self-authenticating. I also just want to distinguish, for purposes of 901 and the statute, I want to try to illuminate a distinction that I think is quite important. This distinction between admissibility and conditional relevance. And I agree that admissibility is a question that is determined by the judge. That's what 104A is about. That's in part what 3505 discusses. Admissibility are things like, hearsay or, other things that are legal questions that don't go to relevance. Or maybe, 403, is this more prejudicial than not? These are legal questions that the judge decides. And hearsay is part of 3505. So the vast majority of 3505, or the first part of 3505 is talking about hearsay. These are the things that render this not hearsay. So that's admissibility. That's under 104A. That's decided by the judge. Authenticity is conditional relevance. That's under 104B. That goes before the jury. There is nothing in 3505 suggesting that authentication doesn't need to go before the jury. I agree that predicates of hearsay generally do not need to go before the jury, that once an admissibility question is decided, it does not need to go back before the jury. But on things about relevance, that is about ultimate evidence, evidentiary decisions that the jury needs to make, establishing predicate relevance. And so that needs to go before the jury. And then lastly, I just wanted to clarify what our challenge is, because I think there was some confusion. Our challenge is to the admission of the spreadsheet period, because specifically because what the judge said is, I am admitting this without any need to connect this up later, because you made a showing pre-trial that sufficed on authentication. That is the error. Now, if the judge had said instead, what you were kind of alluding to, Judge Millett, hey, you made this pre-trial authentication showing, that is enough. If you introduce that at trial, if you connect that up later, that's enough. So I'm going to introduce this subject to connection up. That's what district judges routinely do. But that's not what then if that had been what happened, then we would have raised another challenge later on saying, this isn't enough, they didn't connect it up. And that would be what we're arguing now. But the error was admitting it because initially, because the judge said he was admitting it because of the pretrial showing. And then the judge didn't later withdraw it from the jury, even though the government had not rendered or not provided a sufficient basis for authentication. So I guess there are really those two errors, admitting it and allowing the jury ultimately to consider it because it had this pretrial hearing when actually there was never sufficient evidence of authentication introduced before the jury. And then finally, with the crime of violence, I did just want to talk really briefly about divisibility, because we've all sort of been assuming that the statute is divisible, but I think that the first issue is that it's really not. There are multiple reasons to see that. First, the same punishment here is given for conspiracy and all of these other kinds of ways of violating the statute. The Supreme Court in Mathis has suggested that if there are different punishments, that can show they're different crimes under, but here, they're not. There was no unanimity instruction given to the jury, and the jury was told, this is the first element. These are all ways of finding the first element. And here in the indictment, 3 alternatives were listed. So, it was injuring, attempting to injure, and destroying. There's no textual distinction between injuring, attempting to injure, destroying, and conspiring. And so, we have to treat these all the same. So the Supreme Court has said, if you're doing a whole laundry list of things, that's an indication that these are means. So certainly we have to say that at least injuring, destroying, and attempting to injure are means. And it would be very strange, given the lack of textual, setting off of conspiracy, to say, well, but conspiracy is a different element. Then to discuss just really briefly, the notion that the Pinkerton instruction applied to everything, or the best way for the jury to understand what this conspiracy language meant was to think that actually the judge was just instructing that Mr. Abukhatallah needed to have someone else complete the offense. I just don't think that's plausible. Specifically, as Judge Katsas noted, these are in totally different parts of the opinion. One section where the judge explains Pinkerton liability is with respect to all counts 3 through 18, basically, not 1 and 2, but 3 through 18. This language, conspiracy, just appears in this count. And it appears under the heading, this is the first element. There's just no indication here to think that, this is actually a reference back to this, not committing a conspiracy, but vicarious liability through conspiring when someone else committed the complete offense. And the government.
I had started with you on this point, but what's wrong? So I thought the word conspiracy here is really a cipher. So what's the jury going to do with it? And the answer is probably nothing, unless they're smart enough to read the instructions as a whole and connect up this word to conspiracy to all the conspiracy instructions in count 1, right? But if they're smart enough to do that and read the instructions as a whole, including the forward cross-reference in 3 through 16, I'm going to tell you about Pinkerton liability later, and then the later discussion of Pinkerton liability. Why wouldn't you naturally understand this or participated in a conspiracy to injure as just a shorthand cross-reference forward to the Pinkerton instruction?
Well, I guess for a couple of reasons. The first is, there's no express cross-reference, first of all. Second of all, there's a distinction between the definition of a conspiracy and the instruction defining a conspiracy, and then the subsequent instruction saying, and you can also find everyone guilty of this other substantive offense if they conspire and someone else completes that offense. That's very different from saying, just you are guilty or this person is guilty if he conspires. And that's what that actual language says. It doesn't say, and also, and actually it doesn't even really make sense to say, we're sort of cross-referencing to suggest that there's this vicarious liability addition, but only if someone else completes the offense. It's actually inconsistent with the instruction. That the instruction just says, full stop, you are guilty if you conspire. And the government says, well, it's also compelling that it didn't define the constituent elements of what conspiracy is. But actually, that to me just makes it even more likely that the jury did not understand this to refer up to this Pinkerton instruction. Conspire has a natural meaning. It means agree. If you read these instructions, it pretty much sounds like destroy, injure, agree with someone else, or aid someone else. And that has a meaning. It's also, again, it's under the heading first element. That just doesn't really make sense. Vicarious liability is not a first element. It is not an element at all. It's this additional supplemental theory of liability that goes once all the other elements are met. So it just doesn't really work to say, well, hey, if you conspire and you meet these other elements, well, we're also actually now going to read this instruction many pages before to actually say, nope, that was wrong. We now have to cabin this and only apply this if someone else completed the offense. I just don't think that there's sufficient legal certainty here to conclude that that's what the jury necessarily legally was required to do.
If you have more on your affirmative case, you turn to the sentencing now.
Okay, thank you. The district court calculated the applicable guidelines, considered all the 3553A factors, and varied downward in light of Mr. Abukhatallah's acquittals. The sentence was substantively reasonable. I wanted to address a couple of things. The first thing is Mr. Leonard's talks about how this was an extraordinary variance of multiple decades. But I just want to be clear, in practice, that's just not correct. Mr. Abukhatallah was 47 when he was sentenced. He's 50 now. A life sentence here, when you take into account his life expectancy and and how that's reduced for someone who spent literally decades of his life in prison or will spend his life in prison. I don't think his life expectancy is greater than the time he would be out under a 22-year sentence. He's under a 22-year sentence. He's expected, or he should get released when he's 65. His life expectancy is likely much lower than that. And even if you think, oh, he'll be statistically likely to he'll beat the odds to live a few more years longer than that, we're just not talking about an extraordinary variance here. We're talking about a variance of the kind that we see every single day in district court, and that's basically never appealed. And if it is appealed, usually by the defense, we always lose. So the reason why this case is being appealed, I think, and why this is such an issue is because it's a terrorism case. But terrorism cases are governed by the same substantive reasonableness standard that this court set out in Gardellini, that the Supreme Court set out in Gall, and that requires a degree of deference, a substantial degree of deference to the careful balancing of the 3553A factors done by the district court. And here, the government doesn't dispute that the district court was allowed to factor in the jury's acquittal.
But what's weird about this case is the district court, left to its own devices to apply the 3553A factors, would have been completely with the government on this. And the only reason the court is feeling constrained to do something very different is this idea of acquitted conduct. But like you say, it's regardless of the acquitted conduct, it still is a terrorism case. And when you back out the cause death element, because it's a terrorism case, the terrorism enhancement is doing a lot of work, plus 12 and category 6. And any way you look at it, if that terrorism enhancement is in the case, this sentence is way above the one that he received.
Well, a couple things, Your Honor. First, just to respond to the entire reason that he gave, I don't think it was simply about the jury's acquittals. He did explain that, to respond to your question about, did he feel entirely backed into a corner except for the acquittals? I don't think that's exactly right. He did specifically say that he wasn't comfortable, or he's particularly uncomfortable stacking the sentences for count 1, 2, and 16 because they all were premised on the same conduct and the same property offense. And that's just an independent basis for saying, I'm really not comfortable with how the sentence is turning out. He did say, I think this would be fairly easy without the acquittals, but he didn't say what the sentence he would have given was. I mean, he didn't say specifically, there's no chance I would vary. There's no chance I would take into account these other factors that I've already, described at great length that also weigh in Mr. Catalase' favor. But I guess to address the terrorism enhancement, a couple of things about that. Number one, the government isn't suggesting, and it's not correct, that the district court was required to recalculate the guidelines without the murders and then explain the precise variance from that number. It was permitted to take out the to calculate the guidelines as it was required and then vary from there and fashion a sentence that it believed appropriately balanced the 3553A factors and its other reasons for finding that a life sentence was inappropriate.
Let me ask you about that. So as to the just taken as given, because this is the government's appeal, it's sort of 30 to life range if we back out the acquitted conduct. On the discretionary, set aside the 10, there's on the discretion, this is where he can exercise his discretion that we're all talking about, the 3553 discretion. And yet he ends up with from 30, even if he were at the bottom of the variance, from 30 down to 12, which is less than half of that time period. What reasons can you point me to? So now acquitted conduct's off the table. We've already addressed that. Where can you point me to the opinion where he sufficiently explained the exercise of discretion that would get from, for present purposes, we'll say 30 to 12, or less than half of the non-acquitted conduct guideline?
Sure. Well, three things. First, I want to make clear, I guess Judge Rao might argue this the other way, but he did make clear that this was a package. So he thought that 22 years was the appropriate sentence for all the conduct period. So I think it's not quite right to separate out the 12 years and the 10 years because he wanted to impose a 22
He has no discretion over that 10 years. And if you try to blend it in, that it seems like at some level you're diluting the 924C sentence if you're kind of borrowing from that to up the discretionary one. So really let's just put the 10 years aside for purposes of my question, if you're able. If it's not a fair way of asking the question, then let me know.
Sure.
But just to the things where there's no dispute, there's discretion.
Okay, well, I guess
if it goes at the bottom, you're still, even from 30 down to 12 is a pretty big variance. And what I saw was, and tell me just what I missed, what I saw was less concern about recidivism, credited the defense argument on that. And then he had this sort of mixed bag thing where he said, you've had this life of violence due to conditions in Libya and an oppressive regime and being in prison, but then being the head of this terrorist group. On the other hand, you seem to be hardworking and have good family support.
he also
How does that get done? How does that justify a variance to less than half of if we take the 30 as the absolute minimum just for these purposes?
Right. Well, he also described that he felt that it was inappropriate or very unfair to stack the sentences on the property counts because it was premised on the same.
Not stacking is still how you just get from 30 to, we're varying down from 30 to 12. That's not.
30 would require the stacking because the maximum on these 30 would require stacking because the maximum on these counts is 15 years. Actually, I'm sorry, the maximum on the first two counts, I think is 15 and the second, and 16 is 20. So he needs to stack in order to give anything above 20. And he made clear that he felt that that was not appropriate. But I need to step back a little bit. I think that, I guess, two things. I think it's not quite right that by subtracting out the acquitted conduct, all we do is subtract out the murders. The judge was very clear that he was sentencing based on the culpability and the conduct as assessed by the jury. And I think that he made clear that you could reach the same guidelines result logically without determining that the jury, without necessarily relying on facts the jury necessarily rejected. But I think that the best way to read the sentencing is that he thought that the jury did not find that Mr. Abukhatallah had engaged in terrorism. And I think there are reasons why that is actually a legitimate interpretation of the jury's verdicts. And one that he was entitled to make. The government doesn't dispute that he's entitled to parse the jury's verdicts as he can. I think,
though, Mr. Abukhatallah was in fact convicted of 3 counts that are defined by Congress as federal crimes of terrorism.
That's not, I don't think that's correct.
Material support is defined as a federal crime of terrorism, as is his 1363 count. So
the federal crime, I'm sorry.
Three such counts. So how is it reasonable to simply characterize those as property crimes?
Those crimes are not defined as federal crimes of terrorism. They are defined as federal crimes of terrorism if they appear in this list, which they do, and you attribute to the defendant basically a motive of terrorism. I think he had to intend to retaliate against the United States or change something about United States policy.
All of which the district court found that he did.
Yeah.
Yes, exactly. The district court did make that conclusion. There's no doubt about that. And that's in part why I think the government is wrong in saying that the district court, never considered that this was a crime involving terrorism. I mean, he believed that it was.
So as the government pointed out, though, the district court essentially made a U-turn after making those findings, then later simply, flipped around and said, well, this is a property crime. And
he said that this is
very downward. So how is that reasonable in light of what he found, during, his guidelines calculations, and even what he discussed in the earlier part of his sentencing explanation? How is it reasonable then to vary downward so substantially?
Well, he's in the first part of his opinion, in his guidelines calculation opinion, and then the first part of the sentencing, he is talking about his conclusions about what the conduct was. At the end of the sentencing, he's talking about what he believes the jury assessed the defendant's culpability and conduct to be. And none of the findings made by the jury show that Mr. Abukhatallah was guilty of a crime of terrorism. It's true, the count 1 and count 2, it has the word terrorism in the title, but the actual elements of the crime don't involve terrorism. The jury never made a determination that Mr. Abukhatallah was involved in terrorism. And a huge amount of the evidence that this was a terrorist crime seems very likely to have been rejected by the jury. So for example, the main evidence on this is these cooperators who say, oh, Mr. Abukhatallah hated America, or Mr. Abukhatallah said, I want to kill more Americans. And it's quite clear that the jury rejected the testimony of those cooperators. So I think the best
why do you think someone would go into a United States embassy with an AK-47 on the anniversary of September 11? What motive would that person likely have?
Well, I think that if you are assuming that he is one of the first people to breach the gate, maybe you can infer a motive from that. And I'm not saying, you cannot possibly infer a motive of terrorism from the place where this occurred. I'm saying the judge had, he made, my understanding of the transcript is that he did not believe that the jury credited this. And so I think that you can distinguish between the first wave of the attack, where people are gathering and breaching these gates, as you say, on September 11th, and then what happened later, several hours after that first breaching, where the video really looks like people are kind of meandering along. There's a lot of evidence that people in Libya carry lots of weapons around. Mr. Abukhatallah had a pistol on him at the time that he was arrested. I think it's a little bit different than in the United States, where it would be very shocking to see someone with such a piece of a piece of artillery. But here, I don't think you can you can infer simply from the location, given, like I said, that I think that the jury convicted Mr. Khatallah solely based on its determination that he was there for the second wave of the attack. I don't think you can determine that he was necessarily a terrorist or was motivated by terrorism because he came to the mission after it had already been breached, after all of this destruction had already occurred. So I hope that answers your question.
But suppose we think that the district court's finding that the terrorism enhancement applies is supported by sufficient evidence and not undermined by the jury verdict. Is not acquitted conduct. Don't we then take as a given, we look at the district court sentence in light of both its findings and its explanation, and we have that finding that the terrorism enhancement applies.
I don't think that's right. I mean, we're not challenging, right? We're not challenging here that the terrorism enhancement applies, but and the government isn't challenging the district
Okay, but
court.
then isn't that part of the backdrop against which we evaluate the reasonableness of the sentence?
That is the backdrop against which you evaluate insofar as it is the guidelines range that the district court varied from. But the question here is,
but the sentence, the ultimate reasonableness of the sentence, which is rendered after the district court has found that the terrorism enhancement applies.
No. I don't think so. I think that
okay.
The district court is distinguishing between saying, I am making this finding. I believe that I can rely on facts that the jury did not logically preclude me from making. The jury's verdicts do not preclude me from making, that I find that the terrorism enhancement applies. And the district court is distinguishing between that and here's what I believe the jury's assessment of the conduct and culpability of the defendant was. And in that second piece, I think that the best reading of the transcript is that he was not at that time attributing to Mr. Khatallah a motive of terrorism. And if that's the case, and the government is not disputing that the district court is allowed to parse the verdicts, I think the government is vigorously disputing that it parsed the verdicts that way. But let's assume that I'm right, that is the best reading of the transcript. I think that the district court is allowed to understand the conduct that way. He was there throughout the trial. He would have the best sense of what the jury decided. And again, the government isn't disputing that it has that discretion. And so if that is, in fact, what the district court understood the jury's verdicts to be, then I think we're all in agreement that he can assess the conduct, the sentence, the conduct that he's going to sentence on using that. But let's assume you disagree with me. You think, either the judge didn't say that he was using this higher guideline range, or he was factoring in motive of terrorism. I think this just goes back to my point earlier, which is we're just not talking about that big of a variance in practice. I mean, Mr. Khatallah does not have a life expectancy of 30 years at this point. He doesn't have a life expectancy of probably anything beyond the actual sentence he got. And this is, borne out by tables kept by our government and then research about what it means to be in prison for years. I mean, this is just not the kind of variance.
Sorry, you think 30 to 12, varying from 30 down to 12 doesn't count as a substantial variance if the defendant happens to be relatively elderly, so that either one might be near the end of the defendant's life expectancy?
Well, the sentence is life, and the life expectancy, right, is just not very high. So yes, on paper, this is a substantial variance. In practice, I don't think it is, and the judge was certainly aware of Mr. Khatallah's age. I think in practice, the difference between this and the sentences that you see, or the variances that you see every single day in district court, is just not that meaningful. The government points to, for example, the Caesar case. Well, in that case, you have, I think, a 21-year-old who got a 4-year sentence. I don't remember what her exact range was, something probably 20 plus years. And that is a significant variance in that case. 4 years is a very short sentence. 22 years is a really long sentence, especially for someone who's had the kind of life that Mr. Katala has had, meaning, he was in prison for 10 years. That already takes 5 years off his life expectancy. He's going to be in prison for another 22. That takes another 11 on average. And, even using like otherwise American life expectancy tables, which probably don't apply to someone who grew up in Libya and had the kind of healthcare and environment that Mr. Katala grew up with, we're just not talking about a really big difference in practice. And
it does seem peculiar to judge the reasonableness of a sentence based on how long a defendant might happen to live.
Well, this is actually a method that
may live to be 80 or 90 years old. I mean, that may not be expected, but it's certainly possible.
It's possible. This is a method that I think that the commission uses. I think in general, it assumes, on average, life sentences, I don't remember the exact figure, 400 or so, or around 400 months, because the average person is alive for this long and is this age when they're convicted. And so, I think this kind of statistical methodology is appropriate in assessing the practical difference here. But even if you want to take the 30 years, I mean, I think we can probably agree, the 30 well, I guess I would say 40 to 22 is just practically not a huge variance. And again, stepping back, 22 years is an enormous sentence. It's a very, very long sentence. Even if you think, you think I'm wrong, the judge thought, yes, this is a terrorism case. It's still, nobody died. That is what the jury definitely found. The judge is saying nobody died. I find that this was violent, this was dangerous, but in the end, it was a property offense where American lives were not actually lost. 22 years is a very, very large sentence for that. And I guess then just to pivot to the recidivism issue, what the court actually said was simply, your lawyers have argued that recidivism declines with age, and I don't have a reason to think that's not true for you, which is true. Recidivism, the defense provided evidence that recidivism declines with age, and the government has never suggested to the district court that it didn't. I don't even understand the government to now say that it does. I think my understanding of the government citations are basically that recidivism rates are relatively high in absolute terms for terrorism cases, but that doesn't, undermine the idea that they still decline with age. And so by the time Mr. Katala is a 65-year-old person with, I don't know exactly how many years could really plausibly be left at that point, it's not terribly likely that he's going to stage another attack. And in terms of general deterrence, he did acknowledge that. The judge did acknowledge that as something he was considering. He was very clear that when he was issuing his variance and rendering the ultimate sentence, that depended on all the facts that he had previously discussed in his opinion, in that sentencing, all the letters he'd received. And there is enough here to determine that a 22-year sentence is valid, especially given the standard of review here, which is highly deferential. The last thing I'll say is just, unless your honors have further questions, is that, to the extent that the complaint is, oh, you just didn't explain X, Y, Z enough, that's a procedural argument, and that's not really before the court. What matters is when you look at the sentence, which is a 22-year sentence, is that just substantively unreasonable given the culpability and conduct that was assessed by the jury? And I think the answer is no. I mean, yeah, sorry, it's not unreasonable.
My colleagues have any more questions?
Thanks.
Okay, thank you very much. Mr. Lenners, I know you asked for 2 minutes, but we'll give you a few more than that. We'll give you 5 minutes for rebuttal just because everything's gone so long on the other side. But you don't have to take it all if you're done.
Your Honor, I'd love to get this done in about 30 seconds. I have 2 very brief points I'd like to make on sentencing. I'm not aware of any legal basis for the idea that you measure the variance from the guidelines based upon a defendant's particular life expectancy versus the actual guidelines versus the sentence that was given. As Judge Rao suggested, that would create myriad problems in trying to estimate defendant's life expectancy. So I don't think there's any legal basis for reducing the size of the variance because Katala is older and from Libya. And certainly there's no factual basis to suggest that the district court chose its sentence based upon Katala's expected life time and to release him, shortly before he goes home to die. So there's no legal or factual basis for the defendant's argument in that regard. And then, just to take a step back and look at the bigger picture, this is a crime of terrorism, to be sure, but it's not just a crime of terrorism. And we cited numerous cases in our briefs where courts found lengthy, even 30-year sentences to be substantively unreasonable when those sentences sentenced Americans whose conduct did not result or relate to any deaths. Ali, Umani, Daoud, Khan, all of these cases involved lengthy sentences where no one died. Here, this defendant, no matter how much you minimize his culpability, participated in a terrorist attack on a US diplomatic facility on the anniversary of the September 11th attacks, during which a US ambassador was murdered. If the UBJ members didn't murder Ambassador Stevens, the other militants who were there when the defendant participated in this attack did. This was a horrific offense. It was a world-renowned offense. It wasn't just a terrorist attack. It was one of the most high-profile terrorist attacks in a decade or more. The judge completely lost sight of that fact when he sentenced this defendant, and that resulted in a substantively unreasonable sentence.
I didn't see anywhere in your brief that you attacked the district court's decision not to stack sentences. Is that right?
We didn't mention that part in our brief.
You haven't appealed that itself was a substantively unreasonable judgment by the district.
Not a separate error, Your Honor, but because the substantive reasonableness turns on the amount of the sentence. So how the judge got there in terms of stacking or not stacking.
You haven't objected to his decision. I haven't seen anywhere where you objected or argued here today, since it's a little late now, to that determination that stacking was not appropriate.
We didn't, Your Honor. The guidelines was life.
Mhm.
And under the guidelines, you get there, even though the other three crimes don't add up to life, by going to life on the 924C,
Mhm.
which does have a lifetime maximum, and then using the other sentences to get to the guidelines plus life sentence. So ultimately, the stacking didn't, that decision didn't really play into the district court's analysis.
Okay. Do my colleagues have any more questions? All right, with that, our thanks to both of you for spending your entire morning with us on this case. Your arguments have been very helpful, informative, at least to me. I don't mean to speak for my colleagues, but we really do appreciate all the time and the effort and the thought that has gone into this. And with that, the case is submitted.
This honorable court is now adjourned until Thursday, January 13th at 9:30 a.m.